Good morning, everyone. I hope everybody is having a good morning. Good morning tomorrow, kiddo. Hello, Sandra. Hey, Godless Gritty. Good to see everyone. I have to say, it's a little. My coffee is keeping me going this morning. Hope everybody got a good rest. Yesterday, that was a bit of a surprise. The motions at the end. I'm glad I kept the stream up. Then we got to hear them, but it does appear that the previously held back testimony of Janice Olson, she was not asked on the stand when she testified previously in regards to a conversation that she had with Tammy Daybell, where she relayed that Chad had talked to her about changing her life insurance amount. It was previously declined, but because John Pryor had approached questions to Emma Daybell while on the stand in regards to that life insurance policy, and they then produced the insurance company form with Chad Daybell's signature on it, and Emma Daybell had confirmed that that was her father's signature, but Emma had testified that her mother never spoke to Chad about the life insurance and that they had actually filled out the forms and took care of everything at the school by themselves, just the two of them, without discussing anything with their husbands and without doing anything. And the insurance form had a little box to check that said that Chad Daybell had read and authorized the change. And, well, it kind of contradicted her testimony. Well, left an opening for the prosecution to then bring it up again to Judge Boyce, which they did. Rocky Wixom pled for it yesterday, that they should be allowed to introduce the statement now. They should be allowed to have Janice Olson's testimony in there, which contradicts it. And they did actually get limited scope to actually bring the statement in. And so we'll see that. They also discussed the fact that there will be several rebuttal witnesses. Um, they they estimate the time for rebuttal from the prosecution to be about a day and a half. So today being Thursday, we have Friday, and then we have the long holiday weekend here in the States. Monday is Memorial Day. So pretty much everything's closed. We'll probably resume for perhaps closing statements on Tuesday if they're not done on Friday afternoon, but I doubt it. We should see this case going to the jury early next week. If everything goes the way it's supposed to. Well, you know how that is. Because even though John Pryor said that he had no more witnesses, he did not rest his case yesterday. And he was very annoyed in the motions hearing. He did not get his way. He did not also get his way about Officer Hermosillo, who the state is going to be bringing back. No, godless. It's a race to the jury. Who goes first, Daybell or Trump? Good question. Good question. Good question. I'm thinking, well, I think that did they do closing statements in Trump? I know they rested, but did they do close? I don't think they did closings, did they yet? I did not look at anything this morning yet. But I've been following on that one. I don't know, Godless Granny. What do you think of the judge in that particular case with Trump? Nope, closings are going to be Tuesday. Oh, okay. So yeah, these cases could probably go to the jury, at the same time. Look at that. Morning, Rocket. Morning, Liam. The defense has closed. Did he actually say the statement? I missed it. I know he said in the motion hearing, he said he would be closing this morning. He would be resting. You mean the defense has closed? Oh, for Trump, Liam? Yeah. Yes, he was. Yeah, Diddums was a bit upset. He was a bit upset on with the motions yesterday. Closing statements will be later. I believe, Liam, you are speaking. Hold on. You're speaking about the Trump case. I know you've been following it as closely as I have in the room. I think the Trump judge is really fair. I do too. I think he's really got a tough job. You know, let's just say, like, this is quite the case. Groundbreaking. And he's really been trying to hold it to the middle, and he seems to be like a little bit no nonsense. He's admonished witnesses. He doesn't want to play around. He's got that gag order, which is almost impossible to keep everything under control. It's everyone just not cooperating, so to speak. Just everybody just wants to do what they want to do, you know. I I don't think Merchant wants to disturb the jury's weekend either. I know he seems to be very conscientious of the jury's time also. The same as our judge here, Judge Boyce. He seems very protective of the jury, and I don't think he's going to want to disturb their weekend either. I mean, every day we've got sidebars for scheduling with Judge Boyce. Like every day of trial. Oh, Granny, I just saw your note up above that you can only hang until 11. Court's going to start like any minute, and we do not talk during the court. So, otherwise, I send you a link. Well, if you want to come in later, I send one over near Twitter if you're free. No pressure, though, ever. You well, you're always welcome. Yeah. But it's gonna be. I don't know. We're already a couple of minutes late. I don't know how we're gonna start this morning. Oh, shoot. All right. I'm just checking the feeds again. Sorry about that. It took ages for the judiciary to find a gag order which fits that slant. You know, it that was a rough go too, and I'm not sure. Like, I don't know. He still tries to find ways around it all the time. But I think he finally. I think it finally was obvious that something bad was going to happen if he kept it up. Cannon has been delaying again by hearing irrelevant requests to vacate the trial, which could have been decided over lunch. You know, yeah, she's got a pile of motions to go through. She's been a little she hasn't been putting anything down in actual order form. She's been doing all of those statements. I don't know. there's just so much going on. As much as we would like it to go smoothly or this or that, everything just takes time. It was, to me, I did not even see any of these trials coming to fruition during this year. It just, there's just too many hurdles. I mean, both Jack Smith cases are not, I do not believe are going to be heard this year, but we'll see. There's just too many hurdles. And in how many trials can one person face at the same time? I mean, you're going to be, the schedule has to be kept. You can't be in two places at once.
Rise. Mr. Court is now in session. Honorable Steven W. Boyce, Judge presiding.
And we are starting early this morning.
Thank you. Please be seated.
Not too late.
All right. Good morning, everyone. We're back on the record on CR 22-21-1623, State of Idaho versus Chad Daybell, continuing with the defense case in chief. And if you're ready, Mr. Pryor, we'll go ahead and have the jurors brought in.
Yes, Your Honor.
Thank you.
Perhaps he does have one last witness. Okay, I'm gonna. The jury's going to be coming in, and I guess we'll find out.
All right, please.
I did see what you did there, Liam. Very clever. Now I'm curious. I thought he said he had no more witnesses. Well, maybe it's just a formality to close the case, rest his side of the case.
Here's all present count for Your Honor.
All right. Thank you, Mr. Bailiff. Please be seated. All right. Good morning, everyone. We are on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. We're continuing at this time with the defense case in chief. The court will note all of the jurors have returned and are present. The court's also received the juror affirmation signed by each of the jurors. So thank you again for continuing to follow the court's admonishing instruction as we break each day. At this time, I believe the defense is prepared to call its next witness. Mr. Pryor, if you'd like to call your next witness, you may do so. Yes. Okay, if you'll give us just a minute, we need to get our FTR working.
Okay, it appears there's no audio from Pryor's mic at the defense desk, and it doesn't seem to at the podium either, so we'll get that going. Although the judge's mic is working quite well. He could have decided to bring this witness after he didn't get his way about the prosecution recalling theirs yesterday. Yeah, he didn't get his way about Officer Hermosillo either, who the state plans on recalling. He was quite upset about that.
All right, we're ready to proceed, Mr. Pryor.
Judge, the defense would call Dr. Eric Bartelink.
Eric Bartelink. I believe this is another. Would this be another DNA witness? I'm not sure. Okay, well, we have another witness.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I, Judge?
Yes, and Mr. Pryor, as I understand it, this would be testimony offers as an expert witness. Is that correct?
It is, Your Honor.
Okay, I will not inquire then on the court's exclusionary order. So if you'd like to commence with your direct examination, Mr. Pryor, you may.
Would you please state your name, spell your last name for the record for me, please?
Yes, my name is Eric Bartelink, ERIC. Bartelink is BARTELINK.
And how are you employed, sir?
I'm a professor of anthropology at Chico State University and co-director of the Human Identification Laboratory.
And what is the Human Identification Laboratory?
The Human Identification Laboratory is a forensic anthropology facility, and we provide services to law enforcement throughout the state of California on the recovery and analysis of human skeletal remains related to death scenes and crime scenes.
Okay. And talk to me a little bit about what is forensic anthropology.
So forensic anthropology is a subspecialization of biological anthropology, and it's specifically focused on the analysis of human skeletal remains, including things like estimating sex, age, ancestry, stature, and also things like defects on remains related to trauma, identification methods, and scene recovery of human remains.
Now, you mentioned identification. Would that include situations where there's been suspected burning of the corpse?
The identification part's more about establishing the identity of a deceased person, but we do specialize in the study of burned remains and other postmortem alterations to the body.
Can you tell me a little bit about your educational background?
Yes, I have a BS in anthropology from Central Michigan University, a master's in anthropology from Chico State University, a PhD in anthropology from Texas A&M University.
Are there certain board certifications that you are required to participate in as part of this specialty?
Although it's not required, it's strongly recommended that practitioners become board certified. And I am board certified by the American Board of Forensic Anthropology since 2012.
Okay. Are there any affiliations or organizations that you're associated with or participate with?
There are several, and while these are not qualifications, these are indicate participation in the field. So I am a fellow of the American Academy of Forensic Sciences, and I am the chair of the Organization of Scientific Area Committees Forensic Anthropology Subcommittee.
And how long have you engaged in the practice of forensic anthropology?
I have been involved with forensic anthropology for about 21, 22 years.
Have you done any publications or research?
Yes, I have published many articles and book chapters, as well as books related to forensic anthropology and other areas of biological anthropology.
And in regards of training of your specialty in terms of fire caused issues related to the burning and fire, what sort of training have you had in that capacity?
So, throughout my education, I have learned about burned human remains through coursework and trainings and workshops, but I have personally assisted on over 100 burned remains cases. I assisted with like World Trade Center identification efforts, which involved a lot of burned remains. And so, and our team is the main team who does fire victim recovery for wildfire victims in the state of California.
Okay. Now, you spoke previously about part of your organization is to help law enforcement agencies. Is it primarily your position in aiding law enforcement agencies, or do you help in defense cases as well?
We don't discriminate between whether we work with the prosecution or the defense. So we have assisted the defense in cases where we thought we could provide useful information and perspective about a case.
Okay. And how have you testified before in front of a court?
I have.
And how many times have you done that?
I think it's around 7 or 8 times, and then I've had other depositions.
Okay. and I think I've asked this before, but I'll ask it again. Is there any specialized knowledge or training that you would be required to have as part of your title as a forensic anthropologist?
Yes, you'd have to be a specialist in the anatomy and biology of the human skeleton. You would have to be able to identify postmortem alterations, including burning on human remains, and be able to properly categorize those modifications. And you have to have expertise in how to identify evidence of skeletal trauma on human remains.
Okay. Judge, I previously had marked Defense Exhibit 136. My understanding, and I won't speak for the state, but my understanding is the state has no objection to the admission of 136.
We do not, Your Honor.
All right, and Exhibit 136 then is offered and admitted. Can you explain what the exhibit is, Mr. Pryor?
The exhibit is Dr. Bartelink's report, Judge.
Thank you.
And Judge, for ease of use, and for me and probably everybody else, I'd like to utilize the Elmo. My understanding is the state has a copy of the very document as well, and I'd like, for purposes of publication, to use the Elmo device to publish.
Okay, if you'd like to publish a conforming printed copy of the exhibit on the Elmo without objection from, if there is no objection from the state, you can publish it that way.
Your Honor, we have no objection to that.
All right.
Now, Dr. Bartelink, you were contacted by my office for what purpose?
We were asked to analyze the skeletal remains of Tylee Ryan.
Okay. And I'd like you to go through the process of what steps you took to conduct that review and investigation.
Yes, so me and my colleagues, Dr. Colleen Milligan and Ashley Kendall, came up to Rexburg, Idaho, and did an analysis of Tylee's remains on December 18th. We worked with the Rexford Police Department to unpack Tylee Ryan's remains and to sort them into anatomical position on a table so that we could conduct an analysis. We performed an inventory, which is a tabulation of all of the bones that were present. We also filled in a skeletal diagram indicating which portions of Tylee's remains were present and absent. Because she was already identified, we did not conduct an estimations of sex, age, etc. But we did conduct a trauma analysis by examining each bone to look for any kind of defects or modifications. And we also recorded the pattern of burning across the skeleton.
And the length of time in order for you to do this was approximately how long?
We conducted this in the span of one day, and it was 3 forensic anthropologists working together. And so we were able to conduct that work in approximately a 6 to 7 hour period between the 3 of us.
Okay. So 18 hours between the 3 of you approximately.
No, total of about 6 to 7 hours with us working all together simultaneously as a team.
So but the 3 of you were all engaged in work at the same time, correct?
Correct.
So, and those folks were associates with your organization, is that correct?
Yes, they are professors that work with me in the Human Identification Lab and are professors at Chico State University.
Both PhDs.
Correct.
And both have similar experience and training as you have, is that correct?
Yes, that's correct.
Okay. Now, as part of your review and investigation, you prepared a report, is that correct?
Yes, that is correct.
And I'm not going to go into every word in the report, but in essence, as part of your investigation, what did you discover in regards to the inventory of the remains?
We found that there were certain areas of Tylee Ryan's remains that were absent, and this included large parts of the vertebral column, most of the left and right arms, and large portions of the legs, kind of from mid-thigh down towards the ankle on at least one of the legs.
And Judge, could I utilize the Elmo device at this point?
Yes.
So I'm showing you a illustration from your report, and there is a laser pointer up there somewhere, if you can find it. And then off to your left is a large screen. And if you could just go through in general, the areas that you found were not present at the burial site of Tylee Ryan. And just basically describe each one for me, if you would.
Yeah, so the way that this skeletal diagram is labeled is on the left side is a front view of the skeleton, and on the right side is a back view. Anything that's colored in black was absent, which means we could not identify those portions of the body in the inventory. So we were missing a little bit of the skull from the left eye socket, a little bit here from the back of the skull. And then if we move down towards the limbs, we're missing almost all of the right arm, except for just the shoulder and a small piece of this forearm bone right here. We're missing almost the entire left arm, except for the shoulder. We are missing most of the ribs, but we were not able to label those individually because we could not determine which rib was which because they were burned and fragmented.
Okay, I'll have you stop there for just a moment, and please forgive my interruption, but when you say fragments of the ribs, is it your testimony that the majority of the rib cage was missing?
I wouldn't say the majority, but a large portion of the ribs were not represented in the inventory.
Okay.
Mr. Pryor, I apologize for the interruption. Could I have a quick sidebar with counsel, please?
A very early sidebar, and I'm wondering if this is going to be in regards to evidence. If there's going to be pictures that are very graphic. Judge Boyce is very protective of getting graphic pictures of the victims, especially autopsy pictures, out to the public. I'm sure it's just going to be questioning the intent there. Actually, I shouldn't really be sure because who knows? It's sidebar. We don't get to hear. He may say after. It could be a scheduling thing. It could be a jury problem. It is a little early to be talking about scheduling, Rocket Couch. I agree. But it was quick, and I do think it might be about the evidence that's going to come through in the report on how graphic those pictures
Excuse me,
may be.
Doctor. Judge, may I proceed?
All right. Yes, apologies for that interruption on the sidebar. You can continue, Mr. Pryor.
So I think we were at the last we let off, we talked about, I think my comment was the majority of the rib cage, but you said instead it was a large portion of them.
That is correct.
Okay, and then can you continue with your pointing out the different remains that you were unable to locate?
Yes. So as we move down, we can see that from about the mid thigh area, these are the femur bones, all the way down to just a little bit of the top of the shin bone here, the tibia bone. No bones could be found from those areas. And we had a little bit of the right leg here, missing this section down here. And then on the left leg, we have almost nothing represented from that leg, except for a few small fragments. So we're missing fairly large portions of the skeleton.
You're missing large portions of the skeleton.
That is correct.
Now, you are an expert in the area of forensic anthropology. And you mentioned that you are involved in the recovery as it relates to wildfire victims in California as well. Is that correct?
That is correct.
And that you have, and I don't know how to talk to you about this, but the part of your job is scientific testing of remains and the impact that they can have with fire. Is that correct?
That is correct.
And you conduct experiments in that regard, right?
We have done some training exercises, and colleagues of mine have as well, where we have experimentally burned a willed body donor.
Okay, and I'm going to stop you there. What that is in a situation where someone has identified on their donor card that they would be willing to be part of a testing, scientific testing, and it's And that's how you obtain the body to engage in your testing. Is that correct?
That is correct. And these are for training exercises for law enforcement and for search and rescue personnel.
And explain to me the process of what you did to run these tests of the will donor body.
So these tests typically involve kind of building what sort of looks like a funeral pyre out of pallets.
Okay, and when you say a funeral pyre, are we talking about a small brush fire?
It's usually multiple pallets, probably around 4 or 5.
4 or 5 pallets.
Yeah, to create enough fuel to burn the body.
So this is a large fire.
Correct.
Would the expression a bonfire be appropriate?
Yes, it would be, similar in size to a large bonfire.
Okay. And would it be
Your
possible?
Honor, at this point, I'd like to make an objection and ask for a quick sidebar.
All right, we'll have a sidebar.
Okay, during the sidebar, good morning, Granny.
Morning, how are you?
I'm good, but sidebar crazy this morning already. I don't know what's going on. Like, this is bizarre.
I don't know.
Yeah. Well, thanks for joining us. Like, we don't talk a lot is when they're talking, but I'm glad that you're here. I know you can't stay very long, but I just wanted to let everybody know.
I can stay for another hour.
Oh, awesome. Hopefully they will have a break and we could, because I do want to talk to you. Do you know anything about like the sanctions that Judge Boyce put on that one attorney that filed this like for the people to try to stop the trial in the beginning? I had a couple
Who
questions.
did he sanction? He sanctioned
Radcliffe. None of the participating attorneys. It was actually someone else.
Okay.
Yeah. I'll send you something in DM. Yeah.
Okay.
All right, he's back. Okay.
All right, at this time, the court's determined we need to make a evidentiary ruling and do that outside the presence of the jurors before we proceed further with this. So the jurors will be asked to just please stand up if you would and line up out in the hall, and we don't need a full break. I don't think this will take very long to get through, but we do need to take up that matter, and I think the most efficient way is to do that. So apologies for the inconvenience, ladies and gentlemen of the jury, but if we could have you please exit the courtroom, we'll take up this evidentiary matter.
All right, please.
I think during this is exciting. You get to hear evidentiary motions. Here we go. So maybe you could weigh in on this one for us as they get going.
Okay.
But basically, a non-party attorney filed a motion to stop the trial, saying it wasn't justice for the people. You know how the people can come forward. But he made the mistake of filing it on his own letterhead, and it
All right,
appeared
thank you.
that he
Please
was
be seated.
representing the defendant. He got in so much trouble. It was like,
All right, Mr. Wixom, I understand the state had an objection to this stage of the testimony. If you'd like to lodge the objection, you may.
I'm sorry, Your Honor.
You can go ahead. I understood the state was proposing an objection to this particular line of questioning.
We are, Your Honor, and for the record, we are objecting to the line of questioning with regard to the experiment that it appears the witness is attempting to go into. The basis for the objection, Your Honor, is that while we did receive a 27-page report from this expert, nowhere in the report that I can see did it reference the particular experiment that's being talked about. The biggest concern the state has is under Rule 16, we're entitled to have a summary report of his conclusions, including the data and facts upon which he relied. When we received this report, we provided it to our 2 experts and had them look at the report in preparation for their own testimony. Certainly, I'm prepared here today to respond to and to deal with the conclusions in the summary report as provided, but we didn't have an opportunity to have our experts consider the way and the methodology that he may have used in this experiment we didn't know about in preparation for a potential cross-examination here, nor in preparation for the calling of our own witnesses. And so for that reason, as to the line of questioning, any reference to any experiment, we would object to that being admitted at this time.
All right, and if you'll give me a moment, I'm just briefly reviewing through the report. And so that was admitted as Defense Exhibit 136. And your proffer to the court here, Mr. Wixom, is that contained within that 27-page report, there's no mention of an experiment regarding fires. Is that what you're saying?
That's my understanding, Judge, and I believe that's been confirmed off the record.
All right,
Um,
response, Mr. Pryor.
Judge, this was part of a training exercise to show how he analyzed and determined burn marks, deciding when and where a corpse and how it was burned. So if the court would like me to rephrase it, instead of rephrasing it as an experiment, I can rephrase it as a training in order to help aid him and his organization in making the determinations that they do as part of this. I'm not suggesting in any way at this point the manner and type in which the remains of Tylee Ryan were burned. What I'm suggesting, Judge, is this was a training exercise that his organization engages in as part of his wildfire training, and that he's describing that this is the methodology that they use to do that in this particular isolated incident. I don't think it's necessary in that situation. This report would be 100 pages if I had to put in every training exercise this expert has engaged in to gain the knowledge that he has.
Okay, so to be clear here, you're referencing as part of foundation or his basis of expertise that he's done this type of training before, but what you are not intending to proffer here is some specific evidence relating to a scientific experiment that would apply to the remains in this case. Is that what I'm understanding?
That's absolutely right, Judge. This is a foundational question that deals with Dr. Bartelink's experience and how he makes determinations in terms of folks who are victims of fire.
Okay. Any further argument or response from the state?
Judge, with that proffer, the state would withdraw the objection. It wasn't referenced in the report, so we didn't have a proper understanding. But if it's limited to that purpose, we withdraw the objection.
Okay, and I would find it proper in terms of foundational for expertise to be established under Rule 702. And so with the state withdrawing that, we'll go ahead. If that's where the testimony is heading, Mr. Pryor will let the jurors back in. Of course, if it were going into a realm of some specific experiment that took place relating to the evidence in this case, then likely the objection could be renewed, and I would then issue a further ruling.
And Judge, for clarity with the jury, I think what I will do is rephrase experiment, and with the defense or with the state's permission, I'll use the word training. And that might alleviate any confusion the state might have with where I was going.
Okay, and I think that would help clarify things. So thank you, counsel. We'll go ahead and have the jurors brought back in, and you can continue with your line of questioning, Mr. Pryor.
Thank you.
Now that was that was something. I don't often like right in the middle of it. They haven't really done a lot. I mean, we've had a lot of evidentiary issues during the trial back and forth. Mostly
As
with
soon as he
labeling,
gave the
though.
proffer, I knew that he was going to lose the objection. So it was interesting that he withdrew the objection rather than lose it.
Yeah, it is, especially with an expert witness, right? Isn't it normal to talk about how you got your training and
All
what
right,
you're
thank you,
going to
Mr.
do?
Bailiff. Please be seated.
Yes.
Yeah.
Although I do
All right,
think he was right to object because it wasn't clear that this was not related to this case.
All right, Mr. Pryor, if you'd like to continue on your direct, you may.
All right, and Judge,
Okay, I'm
I'll
going to
start
bring
with,
them full
Dr.
screen
Bartelink.
again.
We were talking about a training that you were participating in terms of utilizing a donor, a willing donor, and engaging in the intentional burning of that donor for purposes of scientific training. Is that correct?
Yeah, it's part of a training course.
Okay, and can you elaborate on what that encompassed?
So essentially setting up something that would be similar to a funeral pyre, but having multiple pallets stacked and cutting out sections of those pallets. So you'd have pallet underneath the donor as well as on top. And we're trying to achieve a certain level of burning in the study. And so it requires the use of a fair amount of fuel source. In this case, it was the wood pallets.
Okay, and when you're talking about a fair amount of fuel source, is that a significant amount of fuel source?
You need combustible materials, and so a body does not easily burn without having combustible materials. And so we using wood is an effective way of achieving a large fire to reduce a body's mass down to the bones.
You used the expression funeral pyre. That would suggest a sizable fire.
Yeah, like a large bonfire.
Okay. And would the use of just gasoline, would that obtain the same result?
So typically accelerants don't generate enough fuel. They burn away quickly, so they don't generate enough fuel to sustain combustion of a human body for a long period of time. So usually you need other types of combustible materials.
And in regards to in regards to a funeral pyre as such, so if I understand you correctly, just the use of gasoline on a donor corpse would not achieve the burning to obtain the results you're looking for.
In my experience, no.
Okay. It would have to require a significant amount of when you say, I think you used the term fuel, that would be wood.
Could be wood or other types of combustible materials.
Okay. Okay. Something that would burn easily
That's correct.
in a large quantity
That's correct.
to generate a significant fire
Yes.
over a long, prolonged period of time
Yes.
to obtain the same result.
Yes.
Okay. Now I'd like to go back if we could utilize the Elmo again, Judge.
Yes, you may.
You pointed out in black on this illustration all of the remains that were not present when you did your review and investigation. Is that correct?
That is correct.
Would the use of a fire be the explanation as to why you didn't have a complete skeleton?
Only partially. So there were bones that could not be identified to a specific skeletal element, but there was so much missing that was not accounted for. So I believe there are a large amount of these remains that are actually missing, but a small amount are bones that I could not identify what they were.
So you reviewed the testimony of the excavation of the site with a bulldozer. Is that correct?
I did review the reports on the excavation of the remains.
And that they used a bulldozer and took care to try to locate all of the remains. Is that correct?
I believe so, yes.
And yet they didn't have the remains.
I don't know where the missing remains are, so I can't comment on
Okay.
that.
But in fact, you don't have all of the remains, correct?
That is correct.
And you believe that the remains could not be determined to have been burned out or disappeared as a result of a fire. Is that correct?
Not entirely, yes, that's correct.
And there are bones missing.
Yes.
Okay. Significant amount of bones missing, right?
Yes, you can see from the skeletal diagram, everything in black was not identified in the remains.
Now, I want to continue with your report. Were you able to make a determination as to whether the body was burned as being intact?
Based on the burn pattern, I do believe that the most likely possibility is that the body was burned as a whole, not in pieces.
Okay. And would it be fair to say you can't make a determination as to the length of time it would take to burn the body?
We could only provide sort of minimum timeframes, but there's, how much fuel is used, the size of the body, and other factors all can alter those parameters.
So there's no definitive way to determine how long it took to put Tylee's remains in the manner in which they were found. Is that correct?
That is correct.
In addition, there were some fragments, and I want to use the word fragments because in the fire pit, there were some objects that were removed from the fire pit. Do you recall seeing that?
Yes.
Are you able to determine what type of fragments those are?
Most of the bones that were in the fire pit lacked diagnostic characteristics, so they could not be identified as being either human or animal.
Right. So we don't know what those fragments were. Would that be fair?
That is correct.
You noted that there was a canine mark on part of the remains of Tylee. Is that correct?
That was not something that I noted, but had been noted by the anthropologist with the FBI.
Okay. And do you recall the location of that canine mark offhand?
I believe it was on one of the shoulders, so where the shoulder connects to your shoulder blade. I don't remember if it was on the left or right side, but it's we made those observations and did not see evidence of scavenging, but sometimes making those determinations is very challenging.
Okay. And I said canine, I meant carnivore.
Yes,
So we don't know when a carnivore may have made those marks on the body. Is that correct?
we do not, and I'm not certain if they're carnivore marks or related to the burning process.
Okay. I want to talk to you about whether you can make a determination as to where Tylee Ryan's body was burned.
I cannot make that determination.
So in other words, you can't make the determination that her body was burned on Chad Daybell's property. Is that correct?
I cannot make that determination.
And you can't make a determination as to the day or time that the body was burned. Is that correct?
That is correct.
What you can make a determination is that the body was burned intact to your best opinion. Is that correct?
That is correct.
Okay. And you can't make a determination as to whether the body was burned and then at subsequent time placed in Chad Daybell's backyard. Is that correct?
That is correct.
Okay. Judge, I have nothing else at this point.
All right, that'll conclude the direct examination then. Mr. Wixom, I presume will be doing cross, is that correct?
Yes, Your Honor.
Okay.
Good morning, Dr. Bartelink.
Good morning.
And am I saying that correctly? It's Bartelink?
You pronounced it perfectly.
Thanks. So, Dr. Bartelink, you've already, I think, shared with the jury that in preparing and in conducting your own analysis of Tylee's remains, you looked at the autopsy report that had been done on Tylee. Is that true?
That is correct.
Likewise, I think you've indicated that you did review the FBI reports from Dr. Angie Christensen and a report from Dr. Halapaska. Is that true?
I did, yes.
Okay. And you have a professional relationship, or at least a collegial relationship, with Dr. Angie Christensen, don't you?
That is correct.
In fact, I believe you both published something together.
We are co-authors on a textbook.
Okay. So is it fair to say that she is a colleague that you have respect for?
Judge, I'm going to object. Witness bolstering.
Sustained.
When you reviewed her report and Dr. Halapaska's report, didn't you indicate in your own that when you compared your findings with theirs and with the autopsy, that you found no substantive difference in the analysis of Tylee's bones?
That is correct.
And you were asked a question by the defense about the ability to estimate a time with which it took to burn Tylee's remains. And I think you concluded that that's not possible. Is that right?
There are just too many variables that are unknown, so I would not feel comfortable making any kind of determination.
In fact, in your report, wasn't that a question that you were specifically asked by the defense in preparation of your analysis?
Yes,
And the question was, can you burn Tylee's bones within a 2-hour period? That's the question.
that was the question. Yes,
Okay. And as I recall from your report, you said it's possible, but you can't determine that. Is that fair?
that is correct.
Likewise, I think you were just asked a question about the ability to determine whether or not Tylee's remains had been burned on the Daybell property. Recall that question.
Yes, I believe I do.
And I think you answered that it's not possible to make that determination, correct?
That is correct.
So is it fair then to say that it may well have been that her remains were burned on the Daybell property?
Judge, objection, not for speculation.
Well, overruled.
You may answer.
It's certainly possible that she could have been burned on the property, but it's also possible that she could have been burned elsewhere.
Fair. I think you indicated that there were, no, you've already indicated that not all of the bones from Tylee's remains were found by the FBI or the search who conducted it, correct?
That's correct.
And you can't tell whether or not all of the bones had been entirely burned out because you don't have all of the bones. Is that fair?
Yes. In my experience, we still would expect to find large portions of the bones that were missing even after the burning process has completed. But there are some bones that were just too fragmented to identify. So some of those could just be those bones, but there's still quite a lot not accounted for.
And didn't you indicate in your report at some point that it's possible there are still bones that remain on the Daybell property?
Judge, objection, speculation.
Overruled.
That is a possibility.
And just to be clear, it's true that there were many of the remains that you analyzed that were subject to thermal damage, correct?
That is correct.
They had been burned.
Yes, that's correct.
Yeah. And in fact, you had found a number of the remains to have had blunt force trauma. Is that correct?
That is correct. Blunt force defects consistent with perimortem trauma.
Yes. And with respect to defects, in fact, didn't you find that I believe the left mandible, I'm going to call it the jawbone if that's not correct. Let me know.
That is correct.
Okay. That the left mandible had been fractured. Is that correct?
That is correct.
I think in 6 different places.
I can't remember the number of places, but there were fractures to the left side of the mandible.
And you did determine that that had been from a blunt force trauma?
Yes, although unable to tell if it's before or after death.
So you can't make the perimortem versus postmortem distinction, but you still believe it was blunt force trauma?
Correct.
Likewise, I think you determined in your analysis that there was blunt force trauma on the skull, the sternum, and the ribs. Is that right?
That is correct.
And there were sharp form defects in the innominate or the hip bone. Is that right?
That is correct.
The sacrum
That is correct.
and the cervical spine.
The ones on the cervical spine are possible sharp force defects, but could not make a definitive determination on those.
And with respect to the sharp force defects, you did indicate that you can't exclude as some of the instruments that may have caused those to have been either a shovel or a pickaxe, correct?
That cannot be excluded. I believe I provided a long list of possible implements.
And in fact, I think you confirmed that some of those traumas could have been from a chopping force. Is that right?
That's correct.
And you indicated a machete may have been used.
That can't be excluded.
And I think finally, you had indicated that there had been some rib fractures. Is that right?
Yes, I believe there were at least 2 rib fractures documented in the report.
And you likewise believe that they were likely caused from blunt force trauma?
Yes, consistent with blunt force trauma.
Finally, I think in your report, you indicated that there were approximately a total of 18 sharp force defects in Tylee's bones, as well as a minimum of 16 impacts that were possible paramortem impacts on Tylee's bones. Is that correct?
That is correct.
Thank you, sir. Your Honor, I have no more questions.
All right, thank you, Mr. Wixom. Mr. Pryor, you can conduct redirect if you'd like.
And thank you, Your Honor. There is no distinguishable way to determine the location, I mean, the specific place where this blunt force trauma took place, is there?
There's not.
Judge, I have nothing else. Thank you.
All right, that will conclude then the testimony of Dr. Bartelink. So I'll inquire next, counsel, if he's to remain under your subpoena, Mr. Pryor.
He is not, Judge.
Okay, you are released then from the subpoena. Thank you for appearing and testifying. You can be excused. All right, Mr. Pryor, does the defense have a next witness to call?
Judge, could we have a sidebar just very briefly?
Yes.
Somehow I just knew that he was going to say that.
I'm thinking at this point, I've only heard bits and pieces of the trial, and I have not heard any of the evidence that directly connects Daybell to the murders. I've only heard his motive and what happened to the kids. But to
Right.
me, that alone is enough to convict him of criminally negligent homicide.
And
Because
that's how the charge is laid out, right?
okay.
And they've got conspiracy in the murder in the Idaho code. He doesn't have to lay hands on they don't have to prove he laid hands on the child. They just have to prove he was actively involved in the plan, ineptly hiding it, obscuring it, covering up, whatever. He's good. That's how they nailed Lori Vallow also in Idaho. And there was actually more physical evidence against Vallow. They had DNA hair on JJ. Like they could prove she had contact. It was on the duct tape, I think. But I agree with you. The hard part is the fact that we know these are children in the condition of the bodies. Has been the hardest part about this case.
Yeah, the other thing is the complete lack of protective capacity. That's something that I deal with all the time as a Kaja. Looking at, should we give these kids back to this parent? Does this parent have protective capacity? And I had one parent that, when I would see her interact with the children, she did love her children, but she had absolutely no protective capacity. Whenever it came down to a question of her or the kids, she always chose herself. And she just did not get that why we would say she can't have her kids back.
They actually did a great job, the prosecution, bringing forward Chad's attitude about small children. We actually heard testimony of him actually through his prophecy, through these powers that he supposedly has, decreasing their ability to handle pain, a 3-year-old child, and then inflicting more pain on that child to try to do something. A 3-year-old. I was so taken aback by that testimony. It really disturbed me that he was actually calling many of the children surrounding the people in this inner circle cultish type thing he had going on dark, and that they needed to have evil spirits removed. Small children. I mean, I'm thinking like what? Like they didn't eat their oatmeal and so they're dark? Like these are small children. How evil can a small child be? It was hard.
This is batshit crazy stuff, and most people would look at this and say, well, I would never go in for something that's stupid. But even the mainstream religious beliefs pick up on enough of that to be horrendous. A particular example that I never can get out of my mind is the time that I saw a woman punish her 1-year-old for not sharing her toys. And, the punishment wasn't harsh. She didn't do anything nasty. I mean, she just put the child in timeout for a minute. It was no big deal. But the thing that I found frustrating is a 1-year-old is incapable of sharing. They don't understand the concept. And when I mentioned that to the mother, she said, well, the child wasn't being obedient. And I thought, well, if you told the child to go make dinner and she was being disobedient, are you going to punish her? The kid doesn't understand what you want.
Exactly. No skill there. How can they possibly be held responsible without
Right.
in context? It's ludicrous, right? But they just don't get it.
But
Yeah.
the religion teaches them that children are always to obey their parents, and if I tell a child to do something, I'm supposed to punish the child if they don't do it. And they don't even take into consideration, hey, does the child know how to do it?
Exactly. I'm going to leave us up because I think the judge, if he's
All right,
resting,
thanks, everyone. At this stage of the proceedings, then, we do need to take up another issue outside of the presence of the jurors. And
I knew
although it's
it.
a little sooner than typical, I think given that this will take a few moments, it's just logical to take have the jurors take the mid-morning recess. We'll take this matter up outside of the presence of the jurors. And so we will have that, and then we'll take a break as well. At the end of the matter we take up outside the juror's presence. So if we could have the jury excused at this time for the mid-morning break, we'll do that now.
All right, please.
All right. So it sounds like they're going to discuss something, and then we'll be able to have a little time to discuss what's going on with this. But I'm glad you saw some of it, Miss Granny, because that's
we
going to make
supposed
it a
to
little
stand up?
easier. Yeah, well, if it was
I'm
Newman, you'd get in a lot of trouble for not standing up right now, But Judge Boyce has not sent any memos out to us that we're not standing during breaks and stuff like so. I do enjoy this judge. He's very direct and he's very even. He's very even.
All right, thank you. Please be seated.
I like what Liam said.
All right, we're on the record now. Outside of the jury's presence, the courtroom's still here in these proceedings. After sidebar with counsel, the court's been advised that at this point, the defense does not intend to call any further witnesses. So I guess the remaining issue or question to address would be whether or not the defendant's going to testify. Mr. Pryor, is that the status of where things stand with the defense case in chief?
Yes, Your Honor.
Okay. Mr. Daybell, I will instruct you that there is going to be a jury instruction in this case the court's going to give. It states, and I'm paraphrasing, that you do have a constitutional right not to be compelled to testify. The instruction will say the decision whether to testify is left to the defendant acting with the advice and assistance of the defendant's lawyer. The jury will be instructed not to draw any inference of guilt from the fact the defendant does not testify, and the jury will be instructed not to discuss or enter into deliberations the issue of the defendant chooses not to testify. If in fact you are going to testify, then Mr. Daybell, there's a further admonishment or advisement I would give you going forward. So let me begin with Mr. Pryor and just first just inquire whether or not you have discussed with your client whether or not he intends to testify.
I have discussed that matter with Mr. Daybell, Your Honor.
All right. And does he intend to offer testimony in this trial?
He does not.
All right. Mr. Daybell, have you in fact discussed that issue with your attorney?
Yes.
And has he advised you of your right to either testify or not be compelled to testify in this trial?
He has.
All right. And it's your decision to not testify. Is that correct?
That is correct.
Okay. Thank you, counsel. I appreciate you clarifying that with the court outside the presence of the jury. So with that, then we'll take our morning recess, and I will ask the defense then in the presence of the jury if they rest their case. And again, the court will provide the instruction to the jurors that they may not consider the decision of the defendant not to testify in their deliberations. With that instruction that'll be provided, So we'll take the mid-morning recess and let's come back on the record in about 15 or 20 minutes. And we'll continue with further witnesses from the state if there are any in the defense resting.
Thank you, Your Honor.
Thank you.
Do you need to use the restroom?
All rise.
Mhm. I'm
Folks,
gonna
please grab all of your
put 'em down
belongings
there.
As you head out.
may hear their
We're
voices a
returning
little
at
bit,
the
but
top of the hour in 30 minutes.
that gives us at least 15 minutes. I'm so glad you could join me. Thank you, Godless Granny.
You're most welcome.
I know that you're not practicing all the time now, but you do have great insight because of your experience, especially as your advocacy that you do. This case is really rough on that issue there. The way the
Yeah.
children were not looked after at all.
I wish he would have testified. I totally get him not testifying. And if I was his attorney, I'd be practically threatening to kill him if he wanted to testify. But
Yeah.
I also totally get, I wish we could have had the opportunity to hear what he had to say in his own behalf.
Yeah. It's not unusual.
Juju's right.
I'm sure.
Prosecution would destroy him.
They absolutely, Juju, yes. And I don't see it going well at all. He doesn't have the demeanor, even just sitting there the way he is giving a very bad impression.
Oh yeah,
just from what we see on the socials.
Face.
Yeah, he's very, very stoic. It's like nothing really gets to him. When they were discussing autopsy, and it was very graphic, there were images we didn't actually, as the public, get to see, although they've been circulated prior, so we knew how bad some of it was. Just the verbal descriptions from the reports and all, it was horrendous. And he sat there, nothing. I mean, the most animated he was when his children were testifying, or when his inner circle, let's say, like two names. I'm going to bring up two names, and you're going to hear the chat groan, even though we can't hear them. I'm going to bring up Melanie Gibb because Pryor is obsessed with that name. He wants to blame everything on this woman for her beliefs. In Zulema, who ended up marrying Alex Cox. When those testimonies were going on, he looked a little like agitated. He took a lot of notes. He spoke to Pryor a lot. He was very involved in what it appeared, I should say, that he was very involved in what Pryor was going to bring up with them, because it seemed like his focus was, they are misrepresenting my prophecy. Like, I know what I'm talking about, and their interpretation of it is making me look bad, and that's not it. You could see it. You could see him getting like I want to say narcissistically pissed off that he was being presented in such a terrible light in regards to his teachings, especially. They seem to be at the forefront of this case. What all of this is about is him thinking he's above everything. He's the prophet. Like, it's up to him, everything that's going on. The control there is so cultish. It creeps me out. Like, this is definitely like cult leader stuff as far as I'm concerned. Yeah.
No question. Yeah.
Yeah.
Now
do you know
his religion was
he started Latter-day Saints.
Okay, so he started out Mormon, but he went into a more out there sect of it, didn't he?
Oh yeah, light and dark, and lots of reincarnations in different planes of living. Like there was diagrams presented by some of the I believe it was Zulema, in regards to his teachings of the different planes and existences that people have. He talks of visiting Lori spiritually to be together, like, even though there was distance, that they spent time in this otherworldly place together. It's really kind of creepy. It's all like about what he wants, though. Like, these things happen, and you can see the manipulation in just to get what he wants. The story he tells, very flattering to the people he brings into his circle about their past lives. They always did something wonderful. There was always something. He kind of keys into what they need to hear.
I'd be interested in hearing what Mormons think of this. I would imagine that most people would be distancing themselves from him and saying, well, That's what he believed. But that's not what we believe. That's not part of our main church.
It's interesting you bring that up. It's been a big part of this trial. With
Mhm.
John Pryor himself, for the defense, has brought forward a lot of pushback on the
Mhm.
beliefs and trying to paint the picture that it's really not that far from LDS. He's really just a
Mm.
traditionalist in the Mormon faith, and he's reviving the traditionalist attitude. But that doesn't go with the fact that, like, he's excommunicated. They don't want nothing to do with it.
Mhm.
Testimony from his own sister-in-law that said the higher ups in the church instructed her to put out an email warning people about these beliefs. There's also someone, Julie Rowe, I believe her name
Mhm.
is, that Chad Daybell conferred with a lot. She started speaking on this and going out there with the castings and things like that. And he was very close to her. And he started to veer in his books and his teachings, so to speak, his private teachings and conferences in that direction. And there's been a lot of controversy in the LDS, from what I understand. I've been researching a little bit, and there's there's like two avenues of thought on it. There's those that just totally think he's going off the rails, and others that think that perhaps because of the 144, he's, they don't want to they don't want to say that all of that doesn't exist, although they doubt that he actually is the chosen one to do it, since they
Mhm.
haven't
Mhm.
sanctioned that. You know what I mean? You know how the
Right.
hierarchy in a religious organization works. It's like, anybody can call themselves a prophet, but if you didn't get permission, well, we're going to kind of side-eye you about that, because, like, shouldn't that be something we're involved with? you know?
That's one of the biggest issues with religion is anyone can be whatever they want to be. I got myself ordained as the deaconess of doubt, and
Mhm.
I'm ordained. I'm ordained
Yeah,
because Shannon Q said so. And
yeah.
Shannon Q can say so because she appointed herself high priestess of the religion of sexual humanism.
There you go, sexual human. I think, that's a good position to have. I'm actually ordained myself. I can actually perform weddings. There you go. I actually married my nephew. Yeah,
I
I
think
can
you
do
should
that.
clarify that you performed the marriage. You did not actually marry
I
your
did
nephew.
not actually. That's, I misspoke. I did not marry my nephew. Okay, I did not. Okay, I did not. I I performed a ceremony which would allow them to call themselves married. There we go.
Right. You officiated at a
I
marriage.
officiated officiated a wedding ceremony, a lovely wedding ceremony, and it was actually one of my fondest memories. I was so honored that they chose me, to do that. So it was kind
Mhm.
of cool. But it is quite easy to get ordained, like, And as far as religion goes, all you have to do is just call yourself a prophet. I don't even
Right.
think you have to fill out an online
Nope.
form. Like, you
Nope.
just, yeah. So yeah, that's been the most disturbing, is his beliefs in, during the Lori Vallow trial, after she got her 3 life sentences, which were on the same charges: murder, conspiracy, and then a bit of fraud with the money, but different. Chad Daybell's facing insurance fraud based on his wife's life insurance.
Mm.
But Lori actually took Social Security money and moved it from accounts after the death and stuff, and kept money that didn't belong to her, and she was convicted on that part. But her statements afterward of totally going to this belief that they're all in a better place, they're grateful that we released them from the evil spirits, they still love me, they're happy. I talk to them, she says, I talk to them regularly. She made statements that she's friends with Tammy Daybell, she's in a better place, and she's okay with everything that's going on with her and Chad. I don't believe.
What's really sad is she probably actually believes that. She probably
She
actually,
yeah,
yeah,
batshit batshit crazy.
religion just can cause you to delude yourself into believing just anything you want.
And that's the word right there, delude and delusional. I feel Chad Daybell also, but for him, I actually, as manipulative as Lori Vallow was, and she's I have to actually say, evil in her manipulations. Oh, she's very cold and calculating. they seemed greed or money oriented, or at least status and affirmation oriented, as far as attention and being like chosen and special, which like the two of them meeting, the world should have exploded the day that those two met, because nothing good was going to happen. Nothing good. Here you got this manipulative man who's looking for getting out of his vanilla life and being like the star. Okay. Chad Daybell, in my mind, is a typical narcissistic. I deserve what everybody else has. I could do it better. Like, I'm gonna, I want the spotlight. The heck with this LDS. It's taken me too long to get my standing in this LDS community. I need to have something just a little special over here. And that's what he was working on doing. And when you met Lori, that just became flattery. And he had someone who was looking for religious guidance in a way for their crazy thoughts about it. And he confirmed them all for her. You watch them in the text messages. He actually confirms every crazy notion that she had in regards to religious teachings, and then made her the star of them and the special one of them. And, oh, you're chosen because you knew better than everybody else.
That's so true of cults, the people and conspiracies. People just feed off of each other. You get one person that agrees with you, and then you form your own echo chamber, and everyone else is against you. So you need to keep out the other voices and just talk to each other.
It's fascinating because, I check out a lot of cults. I've done a lot of research on particular types. I did Keith Raniere, who also was a very controlling person who developed a whole cult around what his desires for his life were. I see the same thing with Chad Daybell. Is very manipulative, even on the sexual side of it, which I found odd based on his religious belief and everything. And, on the one hand, he would say his wife was a wonderful person. They had a great life. She was a really good wife. He really didn't have any complaints. And then he's saying, well, things are vanilla. And then he meets this, like, in his words, this goddess, just coming from some of his fantasy writings that he did to her, this goddess, Lori, who was younger. She is a beautiful woman. She does have a magnetism to her. When she flashes that smile, I think Judge Boyce recognized that in her trial and why he kept the cameras out. It was going to become a circus. She was playing to the camera every time she went into a hearing. The media was eating it up. It was insane. But this whole thing, it's just so narcissistic. I just can't believe what gets me every time. And we say this on my channel. Those in the chat can confirm. We have said repeatedly, why couldn't they just hold hands and walk off into the sunset together? Why do all of these people have to die for them to get what they wanted? That's just greed. That's just an over abuse of power. Nobody would have cared that they loved each other and they wanted this life and they want to start this prophecy of their own and go on. No one needed to die.
I think it makes perfect sense within the religious context. One of the biggest complaints that I make against religion all the time is that the Abrahamic God sees death as the solution to every problem. When a person displeases him, death. When somebody makes a mistake, death. Death is always the answer. And so that's the way they're taught to think, that if there's a problem, somebody needs to die if you want to solve the problem. And, I had Vice Rhino make me a little meme for this, and Junie, the apostate, drew me the picture to go with it, which is a guy it's God sitting at a computer, and Darth Vader is behind him, and he says, "I find your lack of problem-solving skills disturbing." And I bring this up frequently, that the Abrahamic God has no problem-solving skills. He just oh, you're causing a problem. Well, I'll just kill you. And too many religious people see that, and they see that that's the answer. And that's why we have so many people that are pro death penalty, because they think that's the answer to the problem. It's why we see, things like this. I've got, there's someone inconveniently in my way. Well, then I need to kill them.
Yeah, that is such, I hadn't thought of it that way, and until you actually said it, but it makes perfect sense to me now that, yeah, that's exactly what he's going to think. That's the total, that brings the religious power into it. It brings almost like the seal of approval to it as far as they're concerned, because they're doing it for such a religious, it's against their beliefs. There's a religious judgment here. So therefore it's not really murder to them. It's just,
Mhm.
it is
It's
just
transferring them to a better life.
yeah, and that's what they keep repeating. That's what Lori, even in discussing it with her own son, when he was so devastated, she was like, "They're in a better place. You just don't understand. They're happy." And I'm
Even
like,
William Lane
"Wow."
Craig said that. William
Mm.
Lane Craig, in a conversation with Alex O'Connor, was defending the slaughter of the Canaanite children, and his
Mhm.
defense was divine command theory, and the way he justifies that it's okay for God to slaughter children is, well, they're just going to heaven, and heaven's a better place. So yeah, of course it's okay to slaughter children. And
Yeah.
I just wish I could go to William Lane Craig in person and ask him, if God told you to take an automatic rifle and go shoot up an elementary school, would you do it? I mean, the command came from God, and it's divine command there, and they're just going to go to heaven and they're going to be in a better place. Would you
Mm.
go shoot up an elementary school just because God told you to?
Yeah. I wonder how many people would actually say yes when you look at all the stories. God asking you to choose on your children, to sacrifice your own children in His name, to
Yeah.
all of
Most
these horrible stories. Yeah.
most of them respond with, well, God would never say that. And then you have to ask, well, then why did he do it here? I mean, if
Yeah.
God's the same yesterday, today, and forever, absolutely he would do that.
I mean, honestly, how many chapters are there in regards to sacrifice and God asking you to do something that is such a dilemma,
Mhm.
a dilemma for you? The brother stories, the father son stories.
Mhm.
Yeah. Doesn't the story of Abraham involve exactly that? It does, Rocket
Yeah.
Couch. It
Yeah. He
does.
tells him to go sacrifice Isaac.
Yeah.
And supposedly it's a test, but and preachers will tell you it was a test for Abraham, not for God, because God allegedly already knew what he was going to do. Um, and the fact that he would sacrifice the child, that's passing the test. To me, that's failing the test.
Mm-hmm. You would for moral fortitude, I would definitely think so. But that's what gets me, and that's what actually pulled me away from faith, is what happens to innocent people in
Mhm.
regards the lack of intervention for all the horrible things that happen to people who actually don't deserve it for whatever reason. For
Mm.
some being that is supposedly all knowing, all caring, and whatever, and who's taking care of us or whatever. I'm like, nah, really bad job as far as I'm concerned. Like, I can't even believe it. I cannot believe that someone with all of this power, knows everything, can do everything, would allow, and that's the thing there, the allowance of it, the permission of
Mhm.
it, to exist, is mind-boggling to me. I get
Mhm.
that there's got to be balance, yin and yang, light and dark, whatever you want to call it. Like, I understand that's nature, that's science, that's the balance of things, that's the universe. Okay, that's the scales of the universe. Not even going to go there on it, but to allow them to be tipped in such a manner, especially against the innocent. I mean, that just blows my mind. It just blows my mind. I mean, have your judgment against those that deserve to be judged, but a 3-year-old? Now, how do you
Mhm.
judge a 3-year-old? Well, seriously,
And
it's beyond
and
me.
people ask me all the time, well, why do you pick on Christians? Why do you why do you rain on their parade and tell them that their God is dead and tell them that Jesus is dead? Why can't you just let them be? And this is why I
Mhm.
can't just let them be, because when
Mhm.
you just let them be, things like this happen.
It's true. And when people say that to me, I said, I'm not against religion. I'm against the fanaticism of it. I'm against the harm. I'm against organizing to smite other people that go against your beliefs. Like, I'm against all of that. You can believe whatever you want, but if you use it to cause harm to others, then I'm going to be totally against it. I may not believe in this all-powerful being, but I don't really. There's something in me that says that every human on the planet, and I know I'm going to get some heat for this, but every human on the planet needs some type of belief in something. It's in our nature. Like, we need a grounding source. Humans are egomaniacs. Sorry, like, to keep us in check. It's more comfortable to think that something else is in control, because maybe we're just, lazy. We don't want to feel like it's our responsibility to be in control of everything. I don't know. But there's something in me that says that it's almost like comforting within our nature to believe there's something bigger, that there's a bigger
Oh
thing
yeah,
than
it is
all.
comforting.
Yeah.
It
Yeah.
does feel good.
Yeah, so I don't want to take that away from anyone, but to focus on the fact that it causes harm, especially when it's organized in some. There is not a single religious organization out there that is not causing harm in some way based on their beliefs. Their segregation of their beliefs, their labeling of people in their belief, they're determining what's right and wrong in their belief, and taking whole sections of humanity and discarding them based on their belief. I can't find that's acceptable in any way, you know.
hmm And you say you don't want to take that comforting feeling away from them, and
Mhm.
I get that. But on the other hand, if what you can give them in its place is the self-confidence to know that you don't need it, I think that's
True.
better.
Mhm. I think it is better too, in a way, the actual clear vision that is required to look at why you need it and why you want to believe some things that are absolutely absurd, like where that comfort, where that need is coming from, takes a lot of self-reflection that, well, is beyond a lot of people. It's uncomfortable. It's uncomfortable to look at themselves and why they would do it, why they would want to believe it, that they would have to actually look at someone that they admire, like, say, a religious leader like Chad Daybell, a self-proclaimed prophet, that getting comfort, in all of these beliefs, but then they have to look at, like, why is he doing what he's doing? Like, why they don't want to doubt it. Like, they don't want to doubt it. They don't want to actually look at the clear picture of it, because then it literally throws everything out. Once
Mhm,
you start to look, there's too many issues to ignore. Once you
mhm,
actually start to look at it, and I think that's why you get a lot of pushback, because you 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 make them look, and they
mhm.
don't want to
Yeah.
see.
Oh,
Okay, they
yeah,
don't want to.
no question
Yeah,
about that. Yeah.
you make them look. They don't want to see, because once you get that first glimpse, once you start to see, then you're kind of obligated. Then right? And then you
Mhm,
have to do something about it. You got to start weighing things out for yourself. In a lot, well, you speak with a lot of people in the community that have, deconvert, that have left religion, and that
mhm.
is such a long and introspective, and yet process, and it's not easy. Some people are still wrestling with it,
Mhm,
being
mhm.
being out being out of formal religion for years, and still wrestling with it, you know to come to terms.
The video that, I don't know the name of the man that's behind it, but the Satan Sunday School video
Mhm.
that's gone absolutely viral, that's quite the video, talking about what the things that pastors know and won't tell you, because he's spot on. Um, a couple of the questions that he brought up in there are questions that I asked pastors when I was a believer, and I always got the brush off, and I never got why I got the brush off until after I was an unbeliever and realized they knew the answer, but they knew that if they told me the answer, it could break my faith. You know? And you have to wonder how many of these pastors don't really believe what they say, but they're just so invested in it that they can't get out.
Mhm. From what you've seen of Chad in the trial, I don't know how
Mhm.
much you've actually. Do you think he actually believes
Oh yeah.
what he's putting
Oh yeah.
out there?
I think
Yeah.
he's completely deluded.
I
I,
do
I-
too. I think he's quite comfortable in that delusion, actually.
yeah, I don't think he lives in reality at all.
Mm. Listening to him speak with his daughter from the back of the police car, that actual conversation with them back and forth, she actually admires and thinks he's a very religious and good person, in that he knows what's going on. And
Mhm.
she has, from all impressions, including her testimony, worships every word that comes out of his mouth in
Yeah.
regards to what's going on, to the point that her mother has a suspicious death, an autopsy that's marked homicide, and she has no doubt that she's in a better place. Her father didn't, even reconcile it, and I watched her do it on the stand. You could hear the thought process almost. I don't believe she doesn't know that something went amiss. I do think she's justified it,
Yeah,
that he did it for the right reason, to free her mother from something.
right. And you have to ask a person like that, okay, if there's absolutely nothing wrong with killing someone so because it sends them to a better place, then it should be okay to confess to the murder.
Yeah. Why
If
isn't he
if you did
standing
nothing
behind her?
wrong, then talking about what you did should also be okay.
Mhm. Well, in a way, Lori did do that. She was like, they're in a better place. Like, she had no empathy for the victim's family, anything. She was just like, they're in a bit. I did the right thing. They're
But
happy
she di
about it. Like,
but she didn't say what she did.
no, she would never say she did it. No.
Right. And that's
Which
what I'm
shows the
saying. If you
manipulation.
really think that what you did was okay, if you really think that you didn't do anything wrong, you should be able to explain in detail what you did.
Mm, absolutely. We're going to have one more trial too. We still have the death of Charles Fallow. That is now, Lori's going on trial for that in Arizona. Her brother, who confessed to it, um, he's no longer with us, so he can't face charge. I mean, he came up a lot in this trial. The name Alex Cox. Basically, everyone blames him for almost every violent act that happens within this
Of
cult
course,
circle. Okay.
it's easy to blame the dead.
And isn't it convenient that when speaking of his past lives and what his goal is here now on this plane, Chad very adamantly says, you are the protector, you are the enforcer, you are all of this, like going right into his ego, and then saying you're forgiven for all of these acts because they are what needs to be done. Like, you have done no evil, and actually said that, like, Jesus forgave him for everything, and which is something apparently Alex Cox needed to hear for quite a few years. He must be a very, very bad person. I don't know what else that he had done, but his conversations that we saw in text and in messages, he needed that message from Chad. He ate that up like sugar on a spoon.
I'd like to comment on Rocket
Yeah,
Couch's
this one,
comment. Yeah.
the one I don't
I
see.
Yep, I really don't see why it matters whether he believes it. Either he does it and he's insane and he should be removed from society, or he doesn't and he's dangerous and he should be removed from society. And
Oh,
to one, in one respect, I agree with you. Either way, he needs to be removed from society. But if he's insane, he belongs in a hospital, and if he's not insane,
mhm.
he belongs in a prison.
Yeah, I do agree with that. Should be removed from society. I don't think he should have, like, I'm even worried about his life in prison and the effect that he's going to have on everybody around him there. Like, this
Mm,
man,
I didn't
like,
think about that.
that concerns me. It concerns me in regards to Lori Vallow also. Like, their ability to influence and manipulate has
Oh no, I
begun
think
to plague them.
Daybell's going to get killed. People who harm children and people who deliberately harm children do not fare well in prison. And I think if he when he goes to prison, I think he's going to get killed.
Mm. That's of concern too. I'm sure if they're concerned about that, have limited access. But it's a death penalty state. Now, that's the other thing I wanted to talk to you about. They've got the death penalty here for
What state are they in?
Idaho.
Idaho. Okay.
And I don't s- me. I want to see from what you've seen on the trial right now. The first thing you mentioned was that there was no real physical connection to the murders with Chad Daybell. How do you feel that's going to play out for the jury deliberations in regards to the death penalty?
I think it's going to be a major factor. Personally, I'm opposed to the death penalty. I wouldn't give anyone the death penalty. But yeah, I think that's going to be a major factor.
I do too. They say that for the death penalty, one of the major factors, there's several of them, would be the amount of harm. In other words, the number of murders. There's more than one. It definitely qualifies there. Also, the total disregard for human life. There's no empathy here for the victims at all. They can see that with Chad. But the problem is murder, like conspiracy for murder, knowing about a murder, hiding a murder, is not the same thing as laying hands on and murdering. And
Right.
I see they're having a lot of difficulty putting a man to death that they don't know actually committed the murder itself.
I really think Chad Daybell did it. I think he did lay hands on these kids, but like you said, we really don't have sufficient evidence to put him to death over it.
Right. I see my predictions being all along. They will convict him. They definitely will convict him. But whether or not they assign the death penalty, which is the second part of they have to deliberate, I really don't see them going forward with it. I don't think there's enough there for anyone to, with good conscience, say that death is there. Because when you think of the death penalty, it's usually an atrocious murder. It's like the actual disregard for life and actually the laying on hands and, the brutalness of the whole thing. I don't really see them coming to that conclusion as easily. Even as cold as Chad acts with the lack of empathy in the courtroom, they could just say, we call it lack of empathy and total disregard. They could just say irreligious pious. We don't know what frame of mind they're coming from. He presents to people differently that way. It depends on your belief. They could just say he acts this way because he's got nothing to worry about, because he's an innocent man. He's the religious pious. He's not upset. He's not reacting because he didn't do anything wrong. And he's just in his belief, just very calm about the whole thing. To me, I think that's absurd, but I can see where they might, we don't get to ask, right? That's the thing about the judicial system. We don't get to ask religious belief of jurors or anything like that, unless it's actually pertinent to a case. It came up a little bit in the Masterson because of Scientology, but not. You weren't allowed to say, are you a Scientologist? No, you're not allowed to say, do you practice Latter-day Saints? Are you a Catholic? Are you Jew? You don't get to ask, so we have to keep it
But
separate.
there's questions that you can ask that can kind of get to that. I mean, you can ask, what do you do on Sunday morning? And if the answer is, I go to church, well, then they're not a Seventh-day Adventist.
Right.
If they say, I read the newspaper, they probably aren't going to any kind of religious service. So yeah, there's ways to get around that.
Cleverly, for sure.
And people that are really into their religions will not only tell you, I go to church, they'll even tell you what church they go to. They'll tell you outright what denomination they are without you asking.
Yeah.
That was
it might get a relevance objection. Couch is like, yes, it might get a relevance objection. Like, why would it matter?
No, this is voir dire. There's no relevance to voir dire. You can ask whatever questions you want about a juror in voir dire.
Interesting enough, we've had a lot of witness for their like immediate, like stop everything to ask interaction about some bias during
Mhm.
voir dire. Like, there's been some challenges there, which I thought was interesting for the chat to see. We don't get to see that a lot in the trials, like that actual process that one of the attorneys can object to a line of questioning, that there might be some prejudicial issue there that needs to be addressed. One of them has been in exposure to the information of the case. This judge locked this case up a while ago, but it had been in the media for so long. It's very difficult to do that. Currently, Officer Hermosillo is supposed to be recalled by the state prosecution, and yesterday Pryor was having a fit over it.
Mm.
He's actually saying that the law enforcement officer could take an oath saying he didn't hear anything of the testimony since he was
Mm.
removed, that
Mhm.
he would actually take the oath even if he had heard like the information. And I was so offended by that statement to Pryor. And I'm like, you're
Right.
basically calling a law enforcement officer that he would lie under oath whether he heard. This is the same man who heard on the radio a conversation, and or his wife had mentioned something about something that she had heard, and reported it and let it go through voir dire and let himself be questioned about the whole thing. He's been involved from the investigation of the missing children from day one. Of course, he's heard everything. It
Mhm.
was absolutely ridiculous.
Yeah.
Do you have any thoughts on Pryor? I know, like, sometimes attorneys don't like to weigh in on other attorneys. So if you're uncomfortable, just say so. But I would like to
Well,
know what you
it's
think
not
of
that I'm
Pryor.
uncomfortable, it's just I haven't watched enough to really have a good opinion. I've watched bits and pieces here and there, and I just haven't
Mhm.
watched enough to really have a strong opinion either way.
Some people love him. Some people absolutely can't stand the style. I would say he's annoying to me. Oh, I like
Mm.
things a little more direct. So his style, this taking the long circle around everything, like, I don't sometimes I have no idea where he's going with this. But the burning today was a perfect example. I didn't understand exactly what he was getting at first, and then it clicked onto me. There was no reporting of a large fire on Chad Daybell's property. There was no reporting of anything like that, any interference. And so I'm thinking he's just gonna just put some doubt on the jury that it even occurred there. That if he can remove Chad and Chad's property from the body, that would give the jurors some reasonable doubt for him. It was a long haul, but honestly, he doesn't really have much to go by. The bodies were uncovered on the property. Okay, the tools in the shed were directly linked to one of the bodies. Um, Chad is
Mhm.
home, almost every day, all day. He works from home. He's an author. He goes to church. He goes to the library, the BSU library every day. But he had access.
I need to get going. I've got an appointment
Okay.
with one of my Kaja kids, and I need to
Okay.
go out and see him.
I appreciate you giving us some time. It's always a joy to have you here.
Yeah, I really
Thank you.
wasn't expecting this break to last this long.
They're often late. Judge Boyce says
Ah.
15, and then the jury or the attorneys seem to
They've
like,
been gone almost a half an hour now.
yeah. There could have been something happened with the juror or more
Ah,
evidentiary issue, but he usually tells us when he gets back why we waited. We'll see.
okay.
But thank you
Thank
again.
you.
Thank you so
Mhm.
much. Anytime you want, Godless Granny.
Okay,
It's always enjoyable. Thank you so much. Good
Mhm.
luck with your meeting.
Thanks. Bye.
All right, let me pull this up so we don't miss them. Let's see. Yes, trying to remove Chad's property, remove Chad's property from the bodies that were found on his property. Exactly, Couch. It was kind of like what I meant was to put some doubt that the damage to the bodies, some of the most offensive things that the jury has heard in regards to the condition of the bodies and all, that everything happened off the property, so that he couldn't have possibly been the one involved in doing anything to Tylee or JJ. Because, well, if you look at it from a juror's perspective, disposing of a body but actually being the one to kill someone or being involved in the killing of someone are two different things, and would actually equate to two different types of punishment that may be involved, two different types of recourse that we can go down. It's been almost 40 minutes already. Did they go like they didn't go too long? Like, wow, they really are taking a long one. Yeah, I don't have it paused. I was just panicked. Oh. So I don't see, none of the other feeds are up either, right? Yeah. I mean, I'm just looking. Let's see if anybody on the socials. Oh. Oh, there's it. Nope. Nope, the last comment from those inside of the trial, inside the courtroom, are just talking about like they went to break. That's it. No reason. They're saying that the prosecution is going to be doing rebuttal, and that the defense is going to rest. That's it. There is no comment on any of it. But I think most of us had already been thinking that Chad would not testify. That wasn't very surprising, was it? What they're doing over the break, well, there was that little motion, like that little discussion about the objection prior, right? And then it was just a break. Well, yeah, they went at 106. It's actually, you're right, 42 minutes. That's double the time. He initially said 15 minutes, didn't he? Yeah. It's not really a surprise that Chad is not going to take the stand. Not for me, because it's a murder trial. It's very unusual for the defendant to testify in a murder trial. It usually does not go very well. We saw that with Alex Murdaugh. Prosecution is able to then bring up things you may not want out there. Cross can be really, really rough. I think Chad would be decimated by the prosecution in this case if he took the stand, and I'm pretty sure that no matter how it went, it would not be a good look for the jury. He's not going to be able to win over a jury with the way he speaks in the questions that would come up. It's possible to use local demographics to ascertain the spread of beliefs in a church. Oh, you mean in regards to their religious belief, in the saturation in the area as far as the churches and stuff? I see that, Liam. Yeah, that makes sense. And totally. Well, with the resting of the case for the defense, we're going to go into rebuttal. And it looks like next week we'll have deliberations. We do have a holiday weekend here in the United States. So, as I said before, I don't know if the judge would be going into deliberation. I would. It just seems, the way he is so protective of their time, and so considerate, actually, I should say, of their service. And he's very protective. I don't think he would disrupt their holiday weekend with closing statements and giving them deliberation. And we may not even be ready for deliberations or closing statements because we got rebuttal. And yesterday, Rocky Wixom and Rob Wood, They had said like a day and a half. 1 to 2 witnesses, I believe they said a day and a half. I don't either. Yeah, Liam. Oh, I see a comment here in regards to Alex. Hold on. Yeah. We were talking about Alex Cox in his wanting to believe what Chad said. It like really resonated with him. Alex was told those things because they already fit his personality. Chad is not smart enough to prophesy from whole cloth. He always needs to hot read someone. Yes, like the person, like what they need. Yeah. Yeah, just listening to those blessings. Yeah. I get it, Liam. Well, that's what gets the cult aspect of this is quite disturbing to me, and I do worry about Chad's influence on others, in the future. In jail, even when we say that they should be away from society, I really mean it. I worry about Lori Vallow too. Her very manipulative. Just too much. Just definitely too much. It was really nice having Godless Granny up here for a little bit. Well, I am so curious, like what is going on with the break, I'm going to Google, right, guys? Like you can hear me typing because I'm trying to figure out like if something happened that we are not aware of. Yesterday, I did put out the link on the lawyer that was fined for wasting the court's time in the Chad Daybell trial. Judge Boyce was very adamant that this mountain home attorney, this Mr. Ratliff, who basically, the only thing I could think of is it was a PR stunt. I had researched him, and he had done something similar in another trial, basically to get his name out there. But in this case, he actually had some contact with John Pryor. Like they were in the same office, I believe, complex or something like that. And they've had some discussions, and perhaps he was going to work on the trial, but things couldn't be arranged appropriately. I don't know what this was, but trying to actually delay the trial because it was in disservice to the people was bizarre. And he made the mistake, like I believe it was Liam, it could have been Rocket Couch, said in the chat. In the middle of the night, he decides to send out these forms, and he puts them on his legal letterhead, and he signed it as an attorney, and it looked like he was trying to represent that he was representing Chad Daybell, and the judge was so offended. Number one, of the night before a trial, trying to disrupt it. Number two, just thinking all that, like he didn't dot the I's across the T's. Here he is trying to do a manipulation of the court, and he doesn't even bother to have the respect, to do it appropriately, Yeah. Yes, but that penalty, I mean, it's a 1,000 plus. He has to pay a few $100s to the prosecution, over $1,000 to John Pryor, who listed in his documentation to the court that he makes $350 an hour, much less than the state prosecutors. He had some prior contact. Yes, he did. Rocky Couch. I like the way you said that. Yes, he actually did. Previous prior contact. Yes. I don't see anything in regards to the break, and I'm getting nervous because it's so early. It couldn't possibly. It couldn't possibly be like the lunch break. So what did you guys think of Dr. Bartelink's testimony in regards to firing?
Thank you. Please be seated.
Oh, they're back, of course. Okay, here we go. Let's see if they're going to tell us why they were so late.
All right. Thanks for your patience, everyone. We've been tending to a bunch of administrative things this morning while the jurors have been in recess. We are back on the record at this time. If you'll give me just a moment. So going on the record on CR 2221-1623, State of Idaho versus Chad Daybell. The courtroom's open, public present. The jurors are not here. While the jurors are not present, I understand, first of all, the defense intends to rest, and in order just for efficiency, perhaps out of order here, there was an issue that came up with a proposed state's witness that would be testifying this morning. And I think in the interest of time and avoiding a subsequent break, if the parties don't have any objection, I'd like to take up that matter if we could on the proposed testimony of Deputy Cannon, I believe, is the witness. If there's something to discuss or determine outside the jury's presence, perhaps, I don't know if counsel's discussed that, but that was the information I got. So Mr. Wixom, is the state intending to call him after the defense rests?
Yes, he would be our next witness if the court allows.
Okay. And where it's going to be your witness, Mr. Wixom, if you could just make a proffer to the court about what you think may be the issue, and then I'll see if the defense has any either motion or response to his further testimony in your case in rebuttal.
Thank you, Your Honor. I might just do three things. One is what we think he'll say, why we think it's important that we be allowed to call him to say it, and then some legal authority that we think the court can look to.
All right. And before I guess we get there, I should confirm, Mr. Pryor, any objection to taking up that issue out of order before you rest?
No, Your Honor.
Okay, thank you. So, Mr. Wixom, then if you'd like to proceed with the points you were going to make, I'll hear from the defense after that.
Thank you, Your Honor. With respect to the first point, what we believe that Deputy Cannon will testify to, if you allow him to be called again, is that back on October 9th of 2019, when he responded to the attempted shooting call regarding Tammy Daybell, he will testify, and I suspect adamantly, that at no time was he ever shown anything on a computer screen, any pictures. In fact, he'll testify he didn't even set foot, as I recall, into the house. If he did, it was just barely through the doorway. That's the first point of factual point. The second factual point that he would testify to is that in responding, he was in fact approached by Joe Murray, who did tell him that Joe was outside and heard Tammy scream. And so those are the two factual points. We believe that it's important because we've heard testimony very recently from Garth Daybell and from Joe Murray that we feel like we need to rebut on those very points, to contradict those points. The concern I'm sure the defense and the court will have, and we recognize it as a concern, is that we've already called Deputy Cannon. He did not testify to those points before. Well, he certainly did not testify to the point of be shown the computer screen. I don't have the record of his earlier testimony, so I don't want to speak out of turn, but I don't recall that he testified as to the issue of Joe hearing Tammy scream. Your Honor, with the first issue of not being shown anything on a computer screen, that first came up after we released Deputy Cannon. So he was released. So he's not subject to the formal exclusionary order. We see this as a potential issue for possible taint. When he was released, he went back home. He did listen in part to Detective Kai Kamano's testimony. And I think there was a second witness that he had listened to. During Detective Kai Kamano's testimony, I think it was cross, he was asked about the issue of whether or not a picture of a paintball gun on a computer screen had been relayed or shown to Deputy Cannon. Deputy Cannon heard that, and I'll be candid, contacted our office immediately and wanted to come set the record straight. Well, He just heard testimony. So we saw that as an issue. I think we may have even approached that off the record of the court. We didn't call him back in our case in chief. But now the defense has put on this evidence. And on the first point, if the court might recall, and again, I don't want to mischaracterize how the testimony came in, but when I was cross-examining Joe Murray on the point about whether or not Joe had heard Tammy scream and had been outside, I had even opined, leaving the door open directly in my questioning, to the fact that Deputy Cannon may simply have misheard or got something wrong as a mistake. And the witness was very adamant that he did not accept that as reality. He thought it was intentionally inaccurate information. So effectively, Deputy Cannon, his character has been attacked. He's been called a liar in front of the jury. So he wishes, and I think understandably so, whether that's a big factor for this court, he wishes to be able to come and to offer what he believes is the truth, which is simply that never happened. Now, going to the Tain issue, I should further tell Your Honor that when he contacted us after his testimony, we instructed him to stop watching the trial and listening, and he did. After so much time passed and then our case rested, he began listening again, and he listened to Garth Daybell's testimony as well as Joe Murray's. So I need to disclose that. As being pointed out, in our case in chief, we did try to formally call him back, and I think we addressed it with the court, and we were not allowed because he had been listening to testimony, and we understand that. Why we think it's different and why it would be unusual, Judge, is first of all, we look to Idaho Rule of Evidence 615. It says, at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But the court has full discretion to decide what to do in this instance. Then I would further just point to the court to a rule I don't often hear cited in legal proceedings, but it's nonetheless there. Rule 102 of the Idaho Rules of Evidence stands for the very basic proposition that these rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing just determination. The state's position is that, particularly with that first point, it simply is not true that Deputy Cannon was showed any pictures of a paintball gun on a computer screen. And frankly, on the second point, Your Honor, Deputy Cannon his character has been attacked. He's been called a liar. And so we feel like in the interest of trying to ascertain the truth and to secure a just determination on these very narrow issues that we should be allowed to call Deputy Cannon. I will note to the court, I did go back and look at an October 9th report from Deputy Cannon and then a further subsequent report of an interview of Deputy Cannon by the AG's office. And there's nothing in there that contradicts what he might testify to. Frankly, if it never happened, there'd be no reason to see any reference in the report that he was shown any pictures in a computer screen because it said it never happened. So that's really where we're at, Judge. We understand that there's an issue. He has watched testimony. We do think on these very narrow points that the court should allow us to call him.
All right, just to clarify there, Mr. Wixom, in prior testimony, and I'm of course thinking back over it as well, that you said a couple of times he's been called a liar. I don't know that the term he's a liar came out in testimony, did it?
No, I agree. That was just a characterization of.
Okay, so there's been a clear contradiction, you could say, in testimony between two witnesses. I wanted to make sure I didn't recall hearing anyone refer to him as a liar other than an argument here. Is that accurate?
He never used that word, Judge, but as I recall, his characterization of Deputy Cannon's version of the facts was that there had been some intentional inaccuracy. I'll leave it at that. But he did not use an inflammatory word like liar. He did not do that.
Okay, thank you. All right, Mr. Pryor, then there's a proposal by the state in their rebuttal case to call witness Deputy Cannon. You've heard the argument and understand, I'm sure, the issues here, and also that he's also been listened to subsequent testimony. What's the response from the defense on this proposed witness testimony?
Well, Judge, there's a couple of things I'm still a bit confused about. They're going to suggest that at no time, one, that Deputy Coulter viewed a video that was claimed that he viewed. Is that one, Mr. Wixom?
Yeah, I'm not sure that there's a video, but I think the testimony from the witness.
Computer.
Yeah.
It was a Google search of.
Google search, yeah. And two, at no time that Deputy Coulter was inside the home. Is that what the other one?
I believe that what he would say is he had just put his foot into the door and just barely crossed the threshold, but he didn't go inside the home to talk to anybody other than Tammy.
Okay, so Judge, one of my concerns is that we went over his statement at the time of his testimony on cross.
And one other point there, there's a second also statement about him talking to, with Joe Murray and whether he heard a scream. I think that someone said that she screamed or he heard a scream. So that's a separate issue as well that you can address if you'd like. Sorry to interrupt.
And Joe and Judge, one of the difficulties, Your Honor, is that, in reviewing Officer Coulter's report, the very first sentence of his report, and I quote, "On October 9th, 2019 at 21:40 hours, I was talking to Tamara Daybell in her front room of her home." So for Officer Coulter now to say, well, I only just stepped in. Well, that's not what that's suggesting. The first sentence says he was talking to her. And lo and behold, Judge, that computer is in the front room of the home. And he was there long enough to then identify the fact that Garth and his son, or Garth and Chad, were at the front door leading into the kitchen. The concern I have is this, Judge, is that this witness was called, he was cross-examined, and and there was the ability to recross. And now what's happening is they don't like the tone of what was testified to, and the evidence isn't favorable to them. So what they're going to do is engage throughout this rebuttal in a process of trying to discount everything that we've presented in our case in chief. And they're going to start with Officer Coulter and pick these little things that they can differentiate. And they shouldn't be allowed to do it. That's not what rebuttal is all about. They can challenge evidence, but they've excused this witness. They've excused this witness, and this witness has now been tainted by looking at all of this other evidence, by reviewing all of this other evidence. And Judge, you're right. I never called Deputy Coulter a liar. Did I challenge his accuracy of what he said? Absolutely. That's my job, to challenge witnesses as to what their statements are. And the state had a chance to recross, and they elected not to go forward any further and inquire. And now after the case is over, it's sour grapes, and they don't like what has been presented, and they've got to figure out a way to try to punch holes in any little thing they can. And the only problem is this witness has already been tainted. So tainted, Judge, that he's offended by Mr. Wixom's own statement that in some way I've somehow called him a liar. Well, that sounds to me that we don't have a witness who's going to get up there and say, anything that's consistent with his report. What he's going to try to do is prove that he's not a liar. And that's not what this was designed to do. Rebuttal is a whole other purpose. And on the issue of 615, Judge, and excusing witnesses, that's designed when a case starts, and by motion, either party can make a motion to excuse witnesses. That has nothing to do with after the state rests their case, and suddenly they decide that, oops, we shouldn't have released Officer Coulter, and now on second thought, let's bring him back and let's take another crack at the defense's presentation of evidence. I wholly object to this tactic. And if the court opens this door, you're going to open the door to a litany of rebuttal that could go on for days. And it's highly inappropriate.
All right, Mr. Wixom, any responsive argument before I make a ruling here?
Very quickly, Judge. Frankly, Judge, it's certainly not a tactic. Rebuttal is something built into the rules, built into the system. It's part of a litigation of a criminal case. With respect to some more specific points, the state can't anticipate when we do release a witness that inaccurate testimony is later going to be offered by the defense. And that's what we think happened, particularly of the questioning of Detective Kayakamano. In fact, as I recall, I think it was defense counsel who offered that. No witness did. He offered that in a cross question, this idea of being shown something on a computer screen. We can't anticipate that coming in. And so certainly not a last minute tactic. What we have is a situation where evidence has came in that our witness was not directly cross-examined on or directly examined on. We couldn't foresee that these kinds of questions would come up because our positions, they simply aren't true. And so we believe that we're simply applying the basic function of rebuttal, which is to consider evidence that's presented by the defense and then responding to it. That's what rebuttal testimony is. I will acknowledge again to the court, I think the fair concern is whether or not his testimony may have been tainted now by the fact that he's listened to more other portions of this case. We don't think he will be. If the court has questions, he's available for questioning by the court on the stand to explore whether or not he's been tainted. And to voir dire him or the defense counsel if the court permits that. So we certainly, we do believe that these are things that need to be addressed. We didn't have a fair chance to address them. That's what rebuttal's for. We don't think he's been tainted. And so we simply ask the court to give us the opportunity.
All right. Well, I'm considering this. I will note a couple of things. First of all, in terms of the propriety or impropriety of calling him in rebuttal, I do agree with the state's argument here that in a case, the state bears the burden. And so it is the state that's allowed an opportunity for rebuttal witnesses to come in and testify. In this instance, there were some narrow topics that came up in the course of the defense case in chief, which are subject to rebuttal, including this issue of whether or not there was, showing of pictures on a Google search in the residence, as was testified to contradictorily between the witnesses, and also comments that the deputy said, including whether someone said they heard a scream. So it's not improper in any way to allow for rebuttal of those statements. The thing the court is weighing a little more cautiously here is whether or not now the court should permit the witness to return after the witness has been observing or listening in on the testimony. And the court would note that the exclusionary rule under 615 governs that. It's discretionary with the court. There's a lot of cases out there that say that. State versus Slauson, 124 Idaho 753. The granting or denying of a request for exclusion under 615 is a discretionary decision of the trial court. And whatever the remedy is also up to the court in its discretion, according to State versus Christensen, 100 Idaho 631. So I don't have any hesitation determining that this would be appropriate rebuttal. The real question then is whether or not the witness testimony has potentially been tainted, where the witness, having been released by the state, observed the trial proceedings, and the witness would be placed under oath and sworn to tell the truth. So I'm not making any speculation that Deputy Coulter Cannon would not just come in and tell the truth, but the observation of that trial testimony on those very points is somewhat concerning, where the court ordered an exclusionary order for the witnesses when this case started because of the manner in which public access has been provided and the whole case has been live streamed. And essentially, when witnesses are permitted to view and listen to other testimony, whether they do it intentionally or subconsciously, there's certainly an opportunity for a witness to know, exactly what they're going to be asked about, how they would respond to that, think through what some other witness said. And in a typical trial, you just wouldn't be allowing the witness to sit in and watch other witnesses to prepare for additional testimony. So quite honestly, I have vacillated back and forth on this second part of whether or not his observation of the testimony should result in him being excluded from offering this rebuttal testimony. Clearly, the door was opened by the testimony that was given in the defense case in chief. But upon weighing out the discretionary function the court has here and looking at whether or not I think there might be some prejudice that could result from allowing the witness to return and testify after hearing the contradictory testimony does cause me some real concern. And so and I very much appreciate the candor of the state in revealing that Deputy Cannon has listened to the testimony, which further goes to me indicating I think he's clearly and honest in the testimony he's provided at trial in terms of at least what he's testified to under oath in his recollections, as well as notifying by proffer to the state and again to the court that he has in fact heard some of this testimony. So I have no reason to personally question his credibility, but again, the ability to have heard that testimony, and even if it's subconsciously just being allowed to prepare for that, I think ultimately is at least an appearance of impropriety or perhaps an unfair advantage a witness would have if they took the stand on those very issues, knowing exactly what somebody else testified to. So the court is going to not permit his testimony in the case in rebuttal on those topics, not because they're improper rebuttal, but because in this particular instance on these particular topics, he was able to know precisely what was testified to. And with the defense objection, I think it is proper that the jury will be just left to consider not which version of the events they do believe. So for that reason, I am going to grant the motion of the defense to exclude the testimony of Deputy Cannon. So that's going to be the court's ruling on that issue. Mr. Pryor, do you have any questions on that?
No questions, Judge.
Any questions from the state?
No, Your Honor.
Okay, thank you, counsel, for bringing that up to my attention outside the presence of the jurors. At this time, then, we'll go ahead and bring the jurors back in, and then is the state going to have additional rebuttal witnesses today?
Yes, Your Honor, we're prepared to call another witness.
Okay, thank you, counsel. We'll have the jurors return to the courtroom then, and then Mr. Pryor, where we left off is without you having yet rested, so I'll bring up that issue in the jurors' presence, and then we'll proceed if there's rebuttal witnesses by the state this morning.
Thank you, Your Honor.
Wow, 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 wow.
All right, please.
So we're bringing the jury back. We're going to continue. The state, John Pryor should be resting his case, and we're going to be going forward. I think John Pryor should be annoyed with himself. He's losing these motions based on the fact that he keeps opening the door to this stuff. He lost the motion in regards to Olson for the same reason.
All right, thank you. Please be seated. Okay, we're back on the record now on case CR 2221-1623, State of Idaho versus Chad Daybell. We had a morning recess, went much longer than anticipated, but we were conducting some court matters outside the presence of the jurors, and as well as other matters that led to the break being extended. So I appreciate everyone's patience as we move through the morning. When we left off, I had inquired whether or not the defense had another witness to call at this time in its case in chief. Mr. Pryor, does the defense have another witness at this time?
There will be no further witnesses, Your Honor. Defense at this time rests its case.
All right, thank you, Mr. Pryor. At this time then, what occurs next is an opportunity for the state to present any rebuttal testimony through rebuttal witnesses. Does the state intend to call any rebuttal witnesses?
We do, Your Honor. At this time, we're prepared to call Lisa Marie Jensen.
Very well. If you want to call your rebuttal witness, then we'll have that witness brought in and sworn.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Okay.
If you have the mic, it's a little bit weird too. There's one right here.
Thank you.
All right, at this time, Ms. Jensen's been sworn. Before we have further testimony on rebuttal, Mr. Wixom, I am going to inquire on the court's exclusionary order. Ma'am, have you observed any of the trial testimony that's occurred since this case started?
No, I have not.
Okay, have you talked to anyone else about any testimony they have given in trial?
No.
Okay, thanks for your responses. Mr. Wixom, if you'd like to inquire on direct, you may.
Thank you, Your Honor. Ma'am, will you please state your full name for the record and spell it?
Lisa Marie Jensen, LisaMarieJensen.
Thank you. And can you please tell the jury, where is it that you live?
I live in Sugar Salem, Idaho.
And what do you do for a living?
I am an educator at Central Elementary
Okay. And where is that school at?
in Sugar Salem,
Yeah.
Sugar City.
Do you know a Tammy and an Emma Daybell?
Yes, I do.
Tell the jury how you know them.
I run our Title I department and I supervise paras. And I hired Emma as one of my paraprofessionals before she was hired as a third grade teacher. So we worked together. And Tammy Daybell was our librarian and computer specialist.
And I want to draw your attention back to 2019, particularly the beginning of the school year. During that time frame, was Tammy someone who you would regularly interact with or see at the school?
Yeah.
Can you explain what occasions you'd have in the line of your work to interact with her?
Yeah, we didn't, our jobs didn't align necessarily. She was the librarian. Many people often think, oh, you're the reading specialist, so you must work closely. But we just were mostly friends and colleagues at the school.
Did you see her do her work at the school?
Yeah.
How often would you see her doing her work?
A couple times a week.
Okay. And what kinds of things do you recall observing her do while she was working?
She ran our library. She did our computer specialist. She was our go-to if there was something that needed to be done and we didn't know who to do it. Tammy was our girl.
Did you have a chance to observe any physical activities that she did in her work?
Judge, I'm going to object at this point. It's going beyond the scope.
Overruled.
You may answer.
Will you repeat the question?
Did you have an opportunity to observe any physical activities that Tammy did at her work?
Just normal day-to-day physical activities, yes.
Could you describe some of those things to the jury, please?
As educators, we're just on our feet a lot. She was back and forth between the library and the computer lab. She also did recess duty, so she was just all over the school a lot. She was busy.
Overall, do you feel like you had the opportunity to make general observations about her health and wellness?
Sure.
What did you observe about Tammy?
About her health,
Yes, ma'am.
that she was well and healthy and she strived to keep herself that way.
Judge, I'm going to object at this point without any additional foundation.
Overruled.
Any other observations about her health?
She was well.
You just used the word, she strived to keep herself that way. Can you explain to the jury what you meant by that word?
Yeah, she every day. She, even if she had on a dress, she would wear her tennis shoes. I loved that. She she aimed to get steps in. She participated in exercise classes.
Judge, I'm going to object at this point without some additional foundation.
I'll sustain that.
You just mentioned something about steps in. Can you explain to the jury what was the observation that you made and when did you make it about seeing Tammy get her steps in?
I don't know when I would have made that observation, just in the time that I knew her, but she would wear a Fitbit. She exercised frequently.
Judge, I'm going to object at this point and move to strike. There's no foundation to support that.
It's overruled. You can cross on that, Mr. Pryor.
Did Tammy ever, particularly during that last few weeks before her passing, did she ever complain about being sick or feeling unwell?
No,
Do you remember her missing work at all?
no,
In the context of observing her do her work, the physical aspect, did you ever notice her to get tired or exhausted?
no,
Did she ever seem winded to you?
no.
Your Honor, at this time, I have a line of questioning that may involve an evidentiary issue. I think it can get resolved in a sidebar. I don't think it should be brought up in the presence of the jury, but may I ask to have a sidebar?
Yeah, we can have a quick sidebar, counsel.
Oh, I am thinking that this rebuttal is going to be hot back and forth the whole time. Pryor is not happy. Not that I can blame him. I'm sure he sees the potential damage to the defense's case here if they start picking apart the witnesses that he put there. This is not. I see some contention here, definitely. I do admire, though, Rocky Wixom's attempts to keep things cordial and non-influential to the jury like this. That was impressive, actually. But actually, the objections that Pryor is, the more animated he acts in objecting, the jury does see that. I think the judge is correct in telling him to save it for cross. It's not a good look, in my opinion, to the jury that he seems so agitated. It makes it look like there's something here. And I think he would do better if he actually acted like it's a nothing burger. But today is a day of sidebars. We've had quite the morning of sidebars already. I don't think anybody was surprised that Chad Daybell is not going to testify, right? He is definitely drawing more attention than defect. I agree. This is Liam just said this in the chat. I totally agree. Well, not exactly a good look. And he needs to be careful right now. These are the last moments before deliberation, yes? Right now, there's a lot of focus. We're coming to an end. These are the things that they're going to be remembering. I mean, that's just my opinion. He could do better into not bringing so much attention to it. And they're coming back. And Lindsey is wearing the professor's elbow patches. There we go.
Give me just a moment, counsel.
I agree, Liam. Judge, I'd like to object. It's too
All right,
long.
in a sidebar, the court was shown a potential statement that counsel for the defense has been able to review. I don't want that statement published to the court in the objection, but Mr. Wixom, is the proffered statement going to be elicited through a question to this witness?
It would be, Your Honor, yes.
And Mr. Pryor, is there an objection to that proffered statement?
Judge, I do have an objection. It's not only hearsay, double hearsay. Judge, it's also improper impeachment.
Okay. Mr. Wixom, what would be your response, knowing that counsel has reviewed that as well as the court without again referring to any specifics of the statement? What exception would the state argue would apply to have this not be a hearsay statement?
Certainly, Your Honor. In fact, the state takes the position that we don't need an exception because it's not being offered to prove the truth of the matter asserted. It would be offered for the purposes explained on the sidebar. We certainly don't offer the particular statement or its substantive proof. It's contrary to what the state believes. We offer it as an evidentiary point that we think, frankly, is rebuttal to testimony given earlier.
All right. The court's considered this proposed statement and the hearsay rules. Looking at Rule 801C, the court would determine that for the purposes stated by the state, that it's not being offered to prove the truth of the matter asserted, that it isn't a hearsay statement. So for that reason, the objection's overruled and you can continue with your direct, Mr. Wixom.
Thank you, Your Honor. Ma'am, again, calling your attention to the time after Tammy died in 2019. Did Emma ever make a statement to you about why she believed or how she believed that her mother had passed?
Yes.
What did she say to you?
She said that it was related to a blood clot. That's what the doctors were suspecting.
And that was the reason she gave you for her mother's passing?
Yes.
Your Honor, I don't have any further questions.
All right. Thank you, Mr. Wixom. Mr. Pryor, you may cross.
Good morning. Pam, can you tell me on a weekly basis how often you'd have contact with Tammy Daybell?
A handful of times.
What's a handful?
I worked in that building 2 to 3 days a week, so 2 to 3 days a week.
And for what length of time, the 2 or 3 days a week that you would work with her, would you have contact, meaning more than just a casual walk by?
Probably one time a week.
And when you had the one time a week, actually, that you would have this contact, was it just a brief hi or was there a discussion?
There was discussion.
And how long would that discussion take place once a week?
Anywhere from 5 to 20 to 30 minutes if we were eating lunch together.
Okay, and you had a habit of eating lunch with Tammy, is that right?
No, I did not.
Okay, so when would the 20 to 30 minutes, if you didn't eat lunch with her, come from then?
It was not a habit, but it happened in our time together.
Okay, and how often during your time together did you have time to sit down for 20 or 30 minutes and have these meaningful talks with Tammy?
If on the rare occasion that we ate lunch together, we would do that. She would come into my room in the mornings more often.
Okay.
I have 5 other women that work in my room and she enjoyed spending time with them as well. We're all readers, as was she, and she loved to share book ideas with us, and she enjoyed to chat with the other women in my room and myself.
And in this relationship then, would Emma also be one of those to go in the books and do this as well?
Not when no, she was not working for me at that time. She was a 3rd grade teacher at that time.
Okay, and Tammy was the librarian, is that right?
Correct.
And would you agree with me, this is a relatively small school?
Yes.
And when I say small, how would you define small?
15 teachers of regular classes, myself, librarian, PE teacher, principal.
So not a significant amount of distance between one end of the school and the other end of the school. Would that be fair?
That would be pretty subjective, I guess.
Okay. And would it be fair to say that you didn't share the same relationship with Emma that you shared with Tammy in terms of contact?
I probably have a closer relationship with Emma.
Now?
Yes, I still consider Emma my friend.
Okay. But at the time, these once a week meetings of a significant amount of time were with Tammy though, right?
Correct.
And you would describe Tammy as someone who's a bit of an introvert?
Objection, Your Honor. That misstates testimony.
Overruled. It's just a leading question.
Would you consider Tammy a little bit of an introvert?
No, she was a very friendly person. She felt very comfortable in our school and among our colleagues. We're a very close, tight-knit school, and she always felt very comfortable around all of our colleagues.
So you would then say she was an outgoing person?
At school, yes, which is where I knew her.
Okay. And this outgoing person who had met with you once a week would talk about books, right?
Yeah.
Okay. Would talk about what's going on in the school.
Sure.
And then at that time, when you were having meetings and doing these once a week meetings with Tammy, you weren't at the same time doing the same thing with Emma, right?
Not at the same time because Emma was in her classroom.
Okay. But at some point, were you doing the same thing, meeting with Emma once a week and spending these deep, meaningful discussions with her as well?
Emma is my friend. So
Okay.
I would have discussions with her like I would any other friend.
Okay. And this close friend, you describe Emma as a close friend?
Yes.
And this close friend decided with another person that she works with at a school is going to confide in her a very private issue about her mother's.
Objection, argumentative, Your Honor.
Sustained.
So are you suggesting that Emma would share with you a very private issue about her mother's death? Is that what you're suggesting?
It wasn't a private issue. Her mother had passed away and she was sharing the cause.
Well, don't you consider that a private issue?
Objection, argumentative,
No.
Your Honor.
Okay, nothing else, Judge. Thank you.
All right. Well, I'm not going to rule on that objection. Those questions and answers will stand. Mr. Wixom, if you'd like to redirect, you may.
Your Honor, I have no further questions.
Okay. That will conclude the testimony of the witness then. Is there any reason she'd remain under subpoena from the state?
No, Your Honor.
Not
Okay.
from the defense, Judge.
All right. You're released. Thank you for appearing and testifying today. You're welcome. All right. The state can call its next rebuttal witness.
Thank you, Your Honor. The state will call MacKay Abegglen.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Okay, thank you.
All right, the court will note now the witness has been sworn. Before we begin with direct examination, I'll just inquire, Mr. Abegglen, have you listened to any of the testimony that's taken place in this trial, either through the live stream or in any other way observed any trial testimony?
I've not. No,
Okay, have you talked to anyone else about anything they've testified to in this trial?
no.
Okay, thank you for those responses. Ms. Blake, you can inquire on direct.
Thank you, Your Honor. Would you please state your name and spell it for the record?
Jason MacKay Abegglen. That's JASON MACKAY ABEGGLEN.
And do you go by MacKay?
Yes.
Mr. Abegglen, do you know an individual named Garth Daybell?
Yes, I do.
How do you know him?
We worked together at a haunted attraction called the Haunted Mill.
And where's the Haunted Mill located?
It's in Teton, Idaho.
And when you say Teton, Idaho, is that the city of Teton?
Yes.
Do you recall approximately when you worked there with Garth?
I started working there, I think, in 2016, and we had worked together for quite a few years. But I worked like right next to him the year of 2019. We worked, yeah, really close.
And when you say you worked right next to him, can you explain a little bit what you mean by that?
He was just one room over from mine. And so if it was slower, we could like talk to each other and stuff. So,
And with the Haunted Mill, typically how long is that open? Is it a seasonal attraction?
yep, it's open for roughly the month of October.
And so in October of 2019, you were working in close proximity to Garth.
Yes.
At some point, did you and Garth develop a friendship?
Yeah, we did.
Did you sometimes hang out outside of work?
We went to a few haunted houses together after the season had ended. Yeah.
Did you hang out when you were at work and associate with each other?
Yes.
Did Garth generally talk to you about any issues within his family?
Nope.
Do you recall an occasion when he did share something with you about some family issues?
He told me it was the following weekend after his mom's passing. He talked about that.
What do you recall him telling you about that?
I remember he said that he found her when he got home from work, and he didn't know where his father was. And I don't remember if he said that she was in the bed or next to the bed, but she said she was kind of pale and her lips were blue.
On a typical night, when would work end at the Haunted Mill?
We usually left work around 12:30ish. Depending on how busy it was, we would go later. So some nights we'd go until like 1 or 1:30. But
And your understanding from what Garth told you was when he got home, he found his mother.
yeah,
And at that time, her lips were blue and she was pale,
yes,
and that he did not know where his father was.
correct.
I have no further questions.
All right. All right, Mr. Pryor, cross-examination.
Thank you, Your Honor. Sir, what was the work schedule at the Haunted Mill?
We would open around 7:30 and then it would go to midnight, but we weren't able to leave until the rest of the customers made it through the attraction.
And what days of the week would the Haunted Mill be open during the month, just the month of October, correct?
Correct. And it would be open. They changed their schedule. I think the last 2 weeks of the month it was full time, and then the rest of the month it was just on the weekends.
So if I understand correctly, that the last 2 weeks of October would be every day?
Yes.
Did that include Sundays?
No.
So it was Monday through Friday or Monday through Saturday?
Monday through Saturday.
Okay. And the day that the Haunted Mill would close would be the 31st of October,
Correct.
Halloween.
Hmm.
Okay. And do you know the day that Tammy Daybell died?
I do not.
Okay. So when you told the prosecuting attorney that it was the week after her passing, if you don't know what day she died, how do you know it was a week after her passing?
Garth he took a day off after it happened, and then he was back the following weekend. So it's just when I saw him next.
Okay. So it was the following weekend after the date that Tammy allegedly passed away.
Correct.
Did he mention anything about attending funeral services or any memorials the following weekend?
No, he did not.
Did he say anything about having to do visits with his church or anything like that as part of any program the weekend after that?
No, he did not.
Okay. So he indicated that she had blue lips and she had already passed, is that right?
Correct.
Did he indicate to you that at that time he played video games until 3 o'clock in the afternoon?
Objection, Your Honor, misstates testimony.
Overruled.
Did he say anything to you about the fact that he was playing video games until 3 o'clock that evening? Sir,
No, he did not.
did he say anything about hearing snoring coming from the room that night as well, sir?
No, he did not.
Okay. And you and Garth would be such close friends, you went to 2 haunted houses in 3 years?
Objection, Your Honor, misstates the testimony. Argumentative.
Sustained.
Move to strike.
I'll strike that question.
So how many, you mentioned that you went to a couple of haunted houses, is that right, sir?
Yeah, we did that all on the same night.
The same night as what?
It was, I think, the following weekend after our attraction had closed. We just went and visited some other places that were still open.
On the 31st. Who went with you?
It was myself, Garth, Kara Briggs, and Emma Moss.
And this revelation that he supposedly made to you occurred,
Honor, argumentative. Move to strike.
Sustained.
and this statement that he made to you supposedly occurred when during this visit?
Objection, Your Honor, again, argumentative with the word supposedly. Move to strike.
I'll sustain that as well, Mr. Pryor.
Can you tell me when and time, date the statement was made to you, sir?
I was still at work at the Haunted Mill. There were a few other scare actors around us at the time. It was a little bit closer to the end of the shift. Garth was pretty quiet most of the night, and then I kind of went up to him and gave him my condolences, and then that's when he told me that he had found her.
So you weren't particularly close friends, would that be fair?
Yeah, more like close coworkers.
Okay. And this close coworker disclosed to you something very personal about his mother's death, is that right?
Objection, Your Honor, calls for speculation.
Overruled.
This close coworker decided on one day just to disclose a very personal matter about his mother's death to you, is that right?
Correct.
Okay, nothing else, Judge. Thank you.
All right. Ms. Blake, redirect.
Mr. Abegglen, when Garth talked to you about finding his mother, how did he appear?
He did seem sad, so I could tell something was affecting him.
And was he clear to you in his statement that he's the one that found his mom?
Yes.
And was he clear in his statement that his dad wasn't there?
Yes.
I have no further questions.
All right. That will conclude the testimony then of Mr. Abegglen. I don't know if he was here under subpoena from the state, but if so, can he be released, Ms. Blake?
Yes, Your Honor, he may be released.
All right.
Yes, Your Honor.
Okay, thank you for your testimony. You can step down. All right, does the state have another rebuttal witness to call today?
Yes, Your Honor, the state will call Detective Bruce Mattingly.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thanks.
All right, before we proceed with direct on this rebuttal witness, Detective Mattingly, have you observed any of the trial testimony that's taken place since you were last here?
No,
Have you talked to anyone else about the testimony they've given since you were last here?
no.
All right, thank you for responding to those questions. Ms. Blake, if you'd like to inquire on direct, you may.
Thank you. And Detective Mattingly, since it's been a moment since you've been here, would you please remind the jurors where you currently are employed?
Fremont County Sheriff's Office,
And how long have you been employed there?
about 23 years.
What is your current title or position?
Detective Sergeant.
Have you held other positions within the Fremont County Sheriff's Office?
I have. I worked patrol and school resource officer.
And at some point, did you personally become involved in an investigation into Tammy Daybell's death?
I did
Do you recall approximately when you became involved?
about mid-December.
And was that of 2019? And again, is it fair to say that you also were involved in the investigation into the whereabouts of JJ Vallow and Tylee Ryan?
Yes,
Were you also involved in the investigation regarding their deaths?
I was.
At some point, do you recall receiving the results of the autopsy for Tammy Daybell?
Yes,
Do you know if anyone of any of Chad and Tammy's children reached out to the sheriff's office?
Judge, I'm going to object without some sufficient foundation.
Overruled.
And specifically in relation to the autopsy?
I do.
And who reached out?
Emma Daybell or Emma Murray.
Do you know at any point if anyone attempted to make contact with Emma Murray in relation to her request?
Yes. I learned that Detective Kai Kakamanu had attempted to reach
Judge,
out.
I'm going to object without foundation.
Overruled.
I learned that Detective Kai Kakamanu had reached out to, or attempted to reach out to Emma and Garth with no response or callback.
Based on that, at some point, did you do something in relation to the autopsy results and Emma Murray?
I did.
What did you do?
So where none of the family members were able to,
Judge, I'm going to object as non-responsive.
Overruled.
where none of the family members were contacted or had been found, we formed a team and we split up to make contact with most of the Daybell children.
And was that to make contact in relation to the autopsy?
That specifically, yes.
And who specifically were you going to attempt to make contact with?
I was attempting to make contact with Emma.
Do you recall approximately when you attempted to make contact with her?
February 18th, 2021, or after school had let out, so maybe around 4:30.
And well, you said after school had let out. Do you know where Emma was working at that time?
She was working as a teacher at Central Elementary in Sugar City.
And did you attempt to make contact with her at the school?
Yes,
And you said it would have been after school let out?
yes,
Did anyone else go with you to try to make that contact?
yes. That would be Lieutenant Ron Ball with Rexburg Police Department.
And prior to this attempt to make contact, had you personally had any involvement with Emma Murray?
Not personally, no,
You'd not had personal contact with her prior to this?
no.
Were you ultimately able to make contact with Miss Murray that day?
Yes, we did.
Did you have some kind of a recording device on?
Yes,
And was a recording made of that attempt to contact her?
there was.
Your Honor, I have what's been marked as State's Exhibit 427, and defense already has a copy. And the state's intent would be to ultimately ask to publish a portion of that for identification purposes unless there's a stipulation for admission.
There's no stipulation.
Okay, so without stipulation, you may just publish just enough without any content, obviously, that would influence the jury if it doesn't come in, just enough to establish foundation. I'll permit that.
Thank you, Your Honor. And if I may have that, and I'll play from the exhibit for the court.
Very well.
It's been a while, Rick. Yeah. How you been? Fine. It's been.
And I'll pause right there. Detective Mattingly, do you recognize the voices in that recording?
I do.
And who are those voices we're hearing?
Myself and Principal Rich Gardner.
Does this in fact appear to be a correct depiction of the audio recording that you made that day?
Yes.
Your Honor, based on that, the state would move for the admission.
Any objection?
No.
All right, exhibit 427 is admitted.
And Your Honor, the state would intend to play the exhibit partway through.
All right, if you please identify the portions you play when you publish.
And Your Honor, the state will begin to play from minute mark 5:50.
I hit the wrong door. Now you're down at the front. I apologize. I'm Bruce Mattingly with Fremont Sheriff's Office. And the sheriff said that you've been working at trying to get a hold of us.
Yes.
And to talk on the autopsy results. We've been trying to get a hold of you and other family members, but probably been a comedy of errors. We haven't been able to do so.
Okay.
And which is why we showed up here, because we'd like to be able to talk with family, because I know you were the one that made a request,
Yes.
right? So we'd like to be able to do that. And
I'm going to pause here momentarily. Do you know who that female voice is that we're hearing?
That was Emma Daybell.
And did you hear in there where she confirmed she was the one that had requested the autopsy results?
Yes.
I'm going to continue playing. I stopped it at 6:31 for the benefit of the record, and I'll continue playing from 6:31.
because you're here and we're here, want to take a few minutes and talk about that and go over that? Or? Okay. Who is the attorney so we can contact?
So we've worked with Josh Garner before, but right now we don't have an attorney-client relationship with any particular attorney.
Okay. So we
decided we're gonna wait to learn what it is when you're ready to release it.
Okay. That is a choice, but we usually just let family, we always let family know. Personally, I've not had anybody really say that they want to wait. That's a little.
We're just not interested in interviewing, answering any questions. We just want to see it.
Sure.
Not-
We'd like to at least let you know what's in it, and tell you about it. We're not asking for an interview.
I'm going to pause right there, Detective Mattingly. Did you hear Emma again decline to see the results?
Yes.
And what did you tell her in relation to whether or not she would have to be subjected to an interview?
I told her she didn't have to do an interview.
For the record, stopped at minute mark 7:35, and I'll continue playing from there.
So, and of course, like now, if you're always free to leave, you can tell us we're done, anything. We're not looking to ask questions. We do want to just let you know the findings.
And again, stopping at 7:45, Detective Mattingly, did you again hear yourself confirm she would not have to provide information?
Yes.
And starting again from 7:49.
And then later the report will, attorneys will get everything. But where we know it's back, you know it's back, we want to let family know.
Okay.
And let people know what the results are. We can't go in depth on the report, but we can talk and give general findings, at
Okay.
least for now. So would you like that? Would you like to do that? What are your, okay, do you want me to set that up with Josh?
I'll have him call you.
Okay, can I give you my card so he knows who to call? That'd be great. This is the number, right?
Yep.
So, I said that, he knows me, he knows my number. I also, just for preparatory, I was hoping to find you, and I'm glad I did. This number on the back is for victim services, which helps with counseling and anything else because you lost your mom. That's what this number's for, is to help with that.
Okay.
Okay? It is our prosecutor's office. You don't have to talk to the prosecutor. Just say, hey, I'm looking for help with victims services. Here, I'll give you that. And that's for you, for the kids, the rest of your siblings. Okay?
Okay.
And then Josh, he can.
You have Josh's number?
Yeah.
Okay.
And pausing at 9:23, Detective Mattingly, did you in fact offer Miss Murray contact information for victim services?
I did.
Did you also offer her contact information for the prosecutor's office?
Yes.
What did you expressly tell her in relation to the prosecutor's office?
To call the prosecutor's office for the help with the victim services. And more specifically, she didn't have to talk with anyone with the prosecutors.
And playing from 9:23.
All right. Are they building a new school over there?
They are. We're
Which one is
growing.
that?
That's gonna be a junior high, and then they're taking third grade out of this school. This is K-3. They're moving
Wow.
third grade over there. That's 4-6 right now, and
So
then
you're moving over there?
grade. Yeah, I'm moving over there. Across the field, and then they're moving 6th grade over there. There's a junior high down the road that they'll move over there, and then the high school will stay the same. So we're just
Okay.
trying to wait until it's finished. It was supposed to be done by this fall, but
You know how it was.
Especially these days.
For sure. So, are you increasing the principal?
no, it'll be the current principal of the junior high. I'm not sure what they'll use that building for.
Okay.
There was
Alright.
talk about it being a YMCA, but that was just a Sugar City rumor.
I know how small town rumors go.
Yeah, I think they just want a swimming pool, but yeah, so it'll be mostly just rotation.
All right. So I do want to let you know, because we've been having difficulties trying to get a hold of people. Today was the day that we were able to get other deputies, officers to go out and try and find them and make contact one way or another.
Okay.
So, if you hear from other family members or you don't, it might be dependent upon if we were able to find them or not. Okay, so I don't want that to be a big blame. I just want to let you know, hey, if we haven't been able to get hold of anybody, it's important to be able to let people know or have that opportunity. That's what we were working on. So,
Okay,
okay.
thank you.
I'm pausing at 11:13. Detective Mattingly, you were informing her that other family members were going to be contacted. Do you recall that?
Yes.
Do you know who some of the other family members that contact was going to be attempted with?
Judge, objection on foundation.
Sustain.
Based on the investigation, did you discuss things with other investigators?
Yes.
And you indicated that you had met and talked about going out to try to provide results to some of the kids, the autopsy results.
Yes.
Do you know who some of the other individuals from the family were that contact was going to be attempted with?
I do.
And who was that?
Judge, objection, still insufficient foundation.
Overruled.
Garth Daybell, Seth, and Leah.
And was the attempt to reach out to some of those kids going to be done around the same time you were attempting contact with Emma?
Yes,
And at the end of that, did you hear Emma tell you thank you?
she did.
And there was some conversation between you, Emma, and Lieutenant Ball. Did you also hear that?
I did.
I'm going to continue from 11:13.
Josh knows how to get a hold of me. We've talked before, both Vince, he knows how to get a hold of Vince, our office, we're not that big. So have him give us a call, or we can glad to sit down with him and you and talk about it. That is true. He did reach out and he said, Emma called, we're gonna do a schedule, but he says, as far as I know, I'm not representing, but maybe things have changed.
Okay.
So, get that ball rolling. I'd like you to know about that.
Okay.
Okay? But that's, I'm not gonna make anything up or make you do anything. I do wanna let you know.
Okay. Thank you very much.
Yeah. Thank you. Yep.
And stopping at 12:14 or 12:15. Detective Mattingly, at the time you were attempting to share these results with Miss Murray, was this still an active investigation?
It was.
And is it fair to say you were not going to provide her a copy of the autopsy at that time based on that?
Correct.
But you were willing to sit down and go over some of the results with her?
Yes.
There was some talk about an individual named Josh. Do you know who that was in reference to?
I do. That was in reference to Attorney Josh Garner.
At any point, did you attempt to make contact with Josh Garner about this?
We did.
What did you learn?
Judge, objection is gonna call for hearsay.
Sustain.
Your Honor, and I would argue it's not coming in for the truth of the matter, but for why the officer did what he did next.
Judge, it's absolutely coming in for the truth of the matter.
I'm going to sustain that as hearsay, Ms. Blake.
In the recording, did you hear yourself reference that he'd indicated he wasn't actually representing the kids?
Yes.
And was that in reference to Josh Garner?
Judge, I'm gonna move to strike.
It was in the recording.
Overruled.
Yes.
Did Emma ever reach out to the Fremont County Sheriff's Office again in an attempt to get the results?
No.
When you met with Emma, did she tell you anything about concerns regarding her mother's health?
Judge, objection.
Overruled.
She did not.
At the very end of the recording, you say something along the lines of, I do want to let you know. What was that in regards to?
It's in regards to the findings from the autopsy result.
So you wanted to make sure that Emma Murray had access and knew the results of that autopsy.
Yes,
And again, Emma Murray declined to hear those results.
she did.
I have no further questions. Thank you.
All right. All right, Mr. Pryor, cross-examination.
Good morning, Detective.
Good morning.
Would you characterize Emma as being polite on that day?
She was.
Responsive?
Yes,
Okay. Now, the autopsy was performed on December 11th of 2019. Is that correct?
yes.
Okay. And you obtained the results on February 18th of 2021?
No, we had to obtain those earlier. We
Well,
were-
how much earlier did you obtain the results?
I don't recall.
Okay. Well, was it a week?
Probably a little longer.
Was it a month?
Could be about close to that.
Was it possible it was a year you had the results?
No.
Okay, so we know it was close to a month. Is that what you recall?
Thereabouts, yes.
Okay, and you held the results, correct?
Yes.
And then at some point you elected to go notify the family, is that right?
Yes.
Okay, and at the time of the autopsy on December 11th, 2019, well, let me go back. On February 18, 2021, providing the family with the results, that wasn't any kind of an investigative concern, was it?
No.
Okay. And a month earlier, when you had the results, was there some sort of investigative concern with providing the family notification of why their mother was exhumed and an autopsy was done? Officer,
Yes.
what?
Would you repeat the question?
Yeah. The month before, while you held on to the autopsy, is there some investigative concern as to why you didn't let her know right away?
Yes.
And what was the investigative concern?
On whether or not we can release the autopsies, whether we can provide a copy,
Okay.
and how best to go about doing that without violating any rights or with the investigation going on.
So you were concerned about the investigative and not concerned about the rights of the family to know why you exhumed the
Objection, Your
mother?
Honor. This is argumentative and it misstates the testimony just given.
Sustained.
So was there a concern about protecting the investigation? Or was there a concern about holding on to the results until you chose the time to let the family know?
Objection, Your Honor. Argumentative.
Overruled.
You can answer that.
Repeat the question, please.
Was the concern over an investigation, officer? Or was the concern for a month that you wanted to figure out how you were going to tell the family and when?
Both, I would say.
Okay. Now, at the time that Tammy Daybell was exhumed, were there concerns about the Daybell 5 children knowing about why you're exhuming their mother?
Objection, Your Honor. Beyond the scope.
So at that time, I was not a part of the investigation.
Okay, so you're not aware of any reason why they just didn't tell Garth, Mark, Leah, Emma, Seth about why their mother was exhumed? Is that correct?
Objection, Your Honor. This has been asked and answered. He said he wasn't part of the investigation at that time.
Sustained.
Okay. I listened to the first part of the tape, officer. And it seems to mention at about 5:50 that Emma says to you, 5:50 on the tape. And if we need to go back and listen to it, it may take me a little bit, but we can do it if we need to.
Okay, thank you.
You're welcome. And at 5:50 on the tape, makes some statement, Emma makes some statement about trying to get a hold of you folks. Do you remember that?
Yes,
How many times did she try to get a hold of you?
I'm aware of one time.
Are there possibilities that she called other people within your agency or other agencies to get a hold of them about this autopsy results?
Possibly.
Okay. And then you made something comment shortly after that. I believe it was at the 6 or 6:02 mark where you said something about it's been a comedy of errors. What was the comedy of errors?
I made that statement trying to lighten the situation about where I knew Detective Kai Kakamanu had attempted to reach out, left messages. We hadn't heard any returns.
Okay. So you previously testified that you're aware of at least one instance where Emma Murray reached out to find out why you exhumed their mother and what the results were. And then,
Objection, Your Honor. Mischaracterizes the testimony. There was nothing about exhuming.
Sustained.
Okay.
Move to strike.
Strike that.
so you're aware of one phone call where you're discussing with Emma, or trying to discuss with Emma the results of the autopsy. And you're saying that because of all this difficulty communicating with the family, the expression you used to Emma is a comedy of errors to lighten the situation about telling her why her mother died, right?
Objection, Your Honor. Asked and answered and mischaracterizes testimony.
It's a light situation to tell a,
Mr. Pryor, you didn't even answer the question yet before you
I'm going to withdraw the question, Judge. And I'll ask another question if I may.
go ahead.
It's a light situation to notify a daughter as to why their mother died. Is that what you're saying?
Objection, Your Honor. Argumentative mischaracterizes testimony.
Sustained.
Move to strike.
Strike that.
Okay. You made a comment about to take a few minutes and talk about the autopsy results, correct?
Yes,
Okay, so it wasn't just a matter of letting her know what the results were, right? You wanted to talk to her about it.
about the autopsy results,
Right.
yes.
You couldn't just tell her what the results found, right?
I didn't want to just throw that out there, no.
Okay.
Hmm.
You wanted to talk about it, right?
Yes,
Now, as a detective, there's been previous testimony about carrying body cams and recorders. Was it your normal policy to have a body cam and a recorder on when you interview witnesses?
we don't have a policy on that.
Okay, so you chose in this instance to wear a recorder, is that right?
I did,
Did you take an instance to wear a body cam as well?
no.
So there's no policy on it, but in this instance, what you were really trying to do was to capture what her reaction would be when you told her about the results. Isn't that true?
Objection, Your Honor. Argumentative.
Sustained.
Move to strike.
Strike that question.
Isn't it true your motive to talk to Emma Murray was to gauge a reaction on tape?
No,
So with this discussion about her wanting to get a lawyer, well, let me strike that. So from the time she's exhumed to December 11th of 2019 to February 18, 2021, approximately 14 months. In the interim during that time, let's start in December of 2019 when she was exhumed, and for each and every month, at any time, did you go over and try to talk to Emma Murray about what the results of her mother's autopsy was?
what were those dates again?
Well, the day she was exhumed, December 11, 2019, and the day you approached Emma for the first time personally was February 18, 2021, right?
Correct.
And during those interim times, did you, or anybody from your office to your knowledge, go up to any member of the Murray family and say, we're waiting on the results? Did you do that?
No,
Did you go up to anybody in the Murray family or the Daybell family other than Chad and say, there's been some delays in us getting the report, but we really would like to talk to you and we'll do some pre-planning to do that? Did you do that?
I did not.
Okay. So after 14 months, your organization decided en masse that you're going to hit all of the kids and wear recorders and try to go tell the kids about what's going on, correct?
Objection, Your Honor. Misstates the testimony. Argumentative.
Overruled.
Correct?
Yes, sir.
And then at some point, you know who Josh Garner is, right?
I do.
You've had encounters with him, correct?
Yes,
And at some point, you were aware that Emma had retained Josh Garner, correct?
we learned that she had not.
Prior to that time, were you aware that she had had representation through him?
Yes,
Okay, so you knew that there was a potential connection there, correct?
correct.
And would you really blame her, Emma, if after 14 months of not hearing anything from your organization, she's a little skeptical to talk to you folks about what you're wanting to say to her?
Objection, Your Honor. Argumentative.
Sustained.
Move to strike.
Strike that question.
You did mention that you weren't interested in interviewing her and asking any questions. You did say that though, right?
Yes,
Okay. So your explanation is that you wanted to be more sensitive to her about letting her know what the results were, correct?
absolutely.
And you wanted to sit down with her and have an opportunity while the recorder's on to gauge her reaction, right?
I wanted to sit down and discuss that with her, not just for any reaction.
And then at the end, when you're talking about the school, was that also a police tactic to sort of soften her a little bit so that maybe she would open up and talk to you about things?
That was Lieutenant Ron Ball who had made that statement and questioned her about that.
Well, I don't care who made the statement. I asked whether it was a police tactic.
Objection, Your Honor, calls for speculation.
Sustained.
Move to strike.
Strike that question.
And then you suggested to her that she get information from the victim services, correct?
Yes,
Okay. And the victim services, is that an office within the prosecutor's office?
the prosecutor's office helps manage victim services.
So the fancy way of saying that is the prosecutor has the authority over victim services, or when you say manage, they supervise the victim services program, correct?
As I understand, correct.
Okay. So the prosecutor's office, that would be the same prosecutor's office that issued the order to exhume Tammy Daybell, right?
Objection, Your Honor. This is misstates evidence. Prosecutors' offices don't issue orders.
Oh. All right, Ms. Blake, this is part of the reason why I don't like speaking objections, because now you put that out there. I'm overruling the objection. If the witness knows the answer, he may answer that, and you can correct that on redirect.
Would you ask that again, please?
Well, the prosecutor's office was the organization in Madison County and Fremont County to pursue trying to get an order to have Tammy Daybell's body exhumed, correct?
That was done through a prosecutor's office, I believe, in Utah.
Okay.
Hmm.
And the information was to obtain, or the purpose was to obtain information surrounding an investigation of Tammy Daybell in this area as well, right?
Yes.
Okay. So would it surprise you if Emma Murray would be quite hesitant to approach an organization affiliated with the prosecutor's office when she wasn't told her mother was being exhumed?
Objection, Your Honor. Argumentative calls for speculation.
Sustained.
So you gave her information from organizations that are managed and organized by the prosecutor's office, correct?
Yes.
And the purpose of that was that they could utilize those services to maybe have someone talk to them about what's going on in the case, right?
Among other things,
What are the other things?
such as counseling.
Okay. And you're very concerned about the counseling with the Daybell children 14 months after their mother was exhumed, right?
Objection, Your Honor. Argumentative.
Overruled.
Yes.
Well, why weren't you so concerned on the day their mother was exhumed and and the whole family on both sides wasn't notified that they were taking their mother out of her burial site?
Objection, Your Honor. This is argumentative.
Sustained.
I have
Move to strike.
nothing else, Judge. Thank you.
All right, that last question of counsel is stricken. That concludes cross. Ms. Blake, you can redirect.
Detective Mattingly, counsel asked you about Emma being polite. Is that fair?
Yes,
From what you heard in the audio, were you also polite?
I believe I was.
Was Detective Ball polite?
He was.
Were any threats made to Emma?
None.
I think you testified the autopsy report, maybe the results had come in approximately a month before, give or take.
Yes,
And you, in fact, were there to try to share the results of that report with Miss Murray. Is that correct?
correct.
And she declined.
She did.
As part of your employment and work in law enforcement, have you ever been involved in death notifications?
Several.
Do you generally just go and blurt out what the cause of someone's death is?
No,
Do you generally want to sit down and have that conversation?
I do.
And in this case, you were trying to share autopsy results regarding Emma Murray's mother. Is that correct?
Yes,
Would it be fair to say, in your experience, that you would want to sit down and discuss with someone when there's been a finding by a medical examiner that the death was homicide by asphyxiation?
I would.
I have no further questions.
All right, thank you, Ms. Blake. That'll conclude Detective Mattingly's testimony then. And where this is rebuttal, I don't believe he would be recalled for any reason. Is that correct?
He would not, Your Honor. The state would release him.
Okay. You are released from any subpoena you had, Detective Mattingly. Thank you for coming in and testifying today. You can go ahead and step down.
Thank you.
All right, does the state have another witness to call today?
We do not have additional witnesses for today, Your Honor.
Okay, thank you, counsel. The court was advised, as was the jury, of our likely schedule for today. So we are going to recess for the day. We've also got tomorrow off, and we'll resume on Tuesday with additional rebuttal. Is that correct, Ms. Blake?
That is correct, Your Honor.
Okay. Ladies and gentlemen of the jury, then we are going to recess for the day. This is a long break for you. You've continued to comply with the court's admonishing instruction. I wanted to put some special emphasis on that just because in the likely event, being this a holiday weekend, you might be around lots of friends and family. Please advise anyone that is curious about your jury service that you're simply not permitted to talk about the case. I think people generally are pretty good to understand and respect that if you are telling them that that's simply the order of the court. I do appreciate your attentiveness. We'll return on Tuesday for additional testimony. And again, I'll admonish you, please don't discuss the case or talk about any of the testimony with anyone else or with each other. You can only do that during deliberations, and please don't do anything to investigate anything about this case while we have this long recess. So we will return for further testimony starting Tuesday morning. And I appreciate all those in attendance today complying with the courtroom conduct order. With that, then we'll be in recess until Tuesday.
Roy, please.
Okay, I'm going to leave it up just in case he addresses anything with the attorneys. But wow, long weekend, no court tomorrow. I didn't anticipate that. I knew there was no court for Monday, being a holiday, but 4-day weekend, jury out. Wow. This would be an awesome place to work. Yes, with all these short schedules, I don't think we've had many complete days, to tell you the truth, in all like 30 days so far of this court. All right. Oops. Oh, there, caught it. Yeah, sorry about that. I did want to wait and see. Sometimes he does start addressing things with the attorneys when the jury leaves, but yeah. 4.5 days. Yeah, you're right, Shill, because it's a very early dismissal today. We didn't even get to lunch. We're 6 minutes before the lunch break, and we are out for the day. Rebuttal has been interesting. I find it interesting that this is the second time I heard that Garth told someone he discovered his mother's body. I do believe there was an interview previously that I heard that he said the same thing. I find that very interesting that Chad has put out a whole different story. I do recall during the 911 call, maybe you guys do too, that Chad actually interfered in that call when Garth started to speak on that and took over the call. I wonder what the jury will do with that information. I understand why the prosecution brought the friend up to testify. I understand that that is just his statement, but it is evidence, and it was there for the jury to consider. Garth may be giving contrary statements to what Chad has declared as how Tammy was discovered in what the whole event around it. Yeah. Yes, yes, Mindy, I get it. Like, for real, 8:30, 3 most days with an hour lunch, two 30-minute breaks, and the last 30-minute break when it was supposed to only be 15 and went for 45. Like, yeah. Today has been a day of sidebars, extended break. Uh Interesting testimony. I found it very interesting, the last defense witness, based on an expert in forensic anthropology, based on the burning of bodies. I mean, very specific. um to me, that was the defense trying to put some distance between the activities happening on the property, trying to get a little distance between Chad and the event. uh, Reasonable, and probably a good tactic, had there been more there. There was burning going on the property. Now, whether or not the body was burned there or not, there are actually ashes in the burn pit. There was bone fragments. Can't deny that. It definitely does appear that the burning happened there also, but no one has testified that it definitely did. It is weird, especially that Garth was so close to his mom. It's an awkward position that he finds himself in, I'm sure. The defense led with actual witnesses that were family in the beginning, and the rebuttal seems to be based on some of those statements that were made. I will admit that both Garth and Emma did, to me, appear to be quite divisive about law enforcement, including the son-in-law. There were comments made. They're very antagonistic against law enforcement, and they wanted to appear that they were being persecuted against. And I'm not feeling that from law enforcement. And for one, I'm kind of glad that, Detective Mattingly had a cam on, and was recording that conversation, because you can hear that they were not being confrontational. Uh, they were trying to reach out to the family to notify them. And then the family decided they didn't want to know. I don't know. Maybe they left because I caught up. Can I check off hasty getaway for that? Yes, I think so. Hasty getaway. I would say the court made a hasty getaway today for sure. The smell, perhaps, but there's not been testimony of a neighbor coming forward about an odd smell, any kind of burning going on. You have to remember where they actually live. You would have heard people shooting raccoons. It's not unusual for them to burn brush, to burn rubbish, things like that on the property. I guess it was not noticed. There has not been any testimony that I'm aware of, except for the overview of the Google Maps to the disturbance of the land. After the fact. But I guess on Tuesday, we're going to find out more. So if there's not any questions, I am going to enjoy an afternoon break and a long weekend. I may come forward with some true crime. We'll see. I want everybody to enjoy their weekends. There's a lot of catch up to do. I'll either be posting on the community tab or putting up a live or a video. There is a lot going on. But it looks like we're going to be finishing rebuttal early next week, and we are going to jury deliberations by the end of the week, it appears. We could have a verdict by Friday, which would be amazing to conclude this chapter. Either way. Thank you all. Anna states, I figured that farmhouse nearby would have noticed it, but apparently not. It depends on time of day, or whether they thought it unusual. I've been present and also tried to enter at a house burning, and human being smells very distinctive. You know it's wrong. Yeah. I've heard that in other trials and testimony of law enforcement. Yeah. I would be more accepting of Pryor if he was not such a, if he was nicer, he may have been listened to a little bit more. It's his attitude messing him up. Yeah, and his unfortunate phrasing of questions. I can appreciate Detective Mattingly asking him to repeat the question several times because we don't know exactly what the question was. You know what I mean? We kind of infer what he's getting at. He's really slamming law enforcement here. He's trying to justify the attitude of the family, which he has realized came off as not maybe in the best of light to the jury. Or he's trying to justify it. And I don't blame him. I would too. It's not unreasonable that they were in an uncomfortable position. But to actually make statements that aren't factual, well, that's an issue. That's definitely an issue. So, all right. On that, you all have a great day. Enjoy. Mandy, congratulations. Enjoy the long weekend. I'm sure you're going to be so busy getting into the new place, but congratulations. This is a good kind of busy and very exciting, and I'm very happy for you. To everyone else, I hope you're in good health, feeling well on the way to being better. If there is anything that you're dealing with, and I do hope that you enjoy a nice long weekend. I'm gonna miss talking to you guys over coffee in the morning. But I will be here Tuesday morning. We'll have it all set up and we'll be continuing then. And don't forget to like, share, subscribe. If you know anyone that enjoys this kind of laid back approach to relaying the trial, share the link, welcome more into the conversation. This is the best part for me, talking with you all and hearing what you have to say about it. Just as people who enjoy watching true crime, not as a legal representative, a therapist, psychologist, or any of that. Just as one of you. So on that, you guys have a great one, and we'll talk soon.